We'll hear argument first this morning in Case 17-1272, Shine versus Archer and White Sales. Mr. Shanmugam.
Thank you, Mr. Chief Justice, and may it please the Court. The Federal Arbitration Act requires courts to enforce arbitration agreements according to their terms. This case involves a straightforward application of that principle in the context of arbitrability, specifically where the parties have agreed to delegate to the arbitrator the authority to decide whether claims are subject to arbitration. Where the parties have so agreed, the Arbitration Act requires a court to honor that agreement. A court does not have the power to decide the issue of arbitrability for itself and to short-circuit the arbitrator's ability to do so.
Mr. Shanmugam, can we back up and have you explain why we even get to the question presented? Because Shine has no arbitration agreement with Archer. So what is this agreement? It's not between Archer and Shine. How does Shine get to claim the benefit of an agreement Shine did not make?
Justice Ginsburg, there is a question in the case concerning non-parties. The agreements in question are agreements with some of the defendants, not all of them, and so therefore as to the non-signatory defendants, there is a question reserved by the Court of Appeals about the doctrine of equitable estoppel, and that would be an issue for the Court of Appeals to address on remand if this Court agrees with us on the question presented. That is obviously a discrete issue, not reached by the Court of Appeals in the decision below, and again, an issue that would be open on remand. But on the question presented, I think our submission is quite straightforward. The wholly groundless exception on which the Court of Appeals relied has no footing in the text of the Arbitration Act. Where the parties have agreed to delegate the issue of arbitrability to the arbitrator, the merits of that issue are for the arbitrator and wholly for the arbitrator to decide. Sections 2, 3, and 4 of the Arbitration Act all point in the same direction. Where you have a valid delegation, that is treated, as this Court has indicated, like an antecedent agreement to arbitrate. And all there is for a court to do is to determine first that that provision is itself valid, and second, to determine whether the opposing party is in fact resisting the enforcement of that provision.
I'm not sure your answer to Justice Ginsburg is totally responsive. The question of whether or not there is a valid arbitration agreement between the parties is antecedent to an order compelling arbitration. The Court makes that decision. And I wonder why this isn't a similar question. I mean, your friend on the other side makes the argument that, well, parties would not have agreed to submit wholly groundless questions to the arbitrator, and so you should treat it as the same type of question.
So, Mr. Chief Justice, I think there are two parts to your question. First, to pick up on my response to Justice Ginsburg, we are certainly not disputing that the issue of equitable estoppel, the issue of which parties are bound, is an issue that goes to validity. It's an issue for the Court to decide. So, again, on remand, that would be a question for the Court of Appeals in the first instance. The Court of Appeals explicitly did not reach that question because of its holding on the wholly groundless exception. It said that a requirement that arbitrability goes to the arbitrator was not enforceable as to anyone, even as to the signatories to the agreement. I think as to the second part of your question, again, we think that the question of whether or not there is a valid agreement more generally is a question for the Court. And so if, for instance, there were some question about the validity of the delegation provision, say a question about whether the delegation provision is itself unconscionable, that would again be a question for the Court to decide. But I think that on the issue of arbitrability, this Court has said time and again, most recently in the first options case, that arbitrability can be delegated where there is a sufficiently clear delegation, and once the issue is delegated, it is for the arbitrator.
Well, the clear and unmistakable delegation, why can't it be both? That is, that the arbitrator has this authority to decide questions of arbitrability, but it is not exclusive of the Court. We have one brief saying that that is indeed the position that the restatement has taken?
So all of the courts of appeals to have considered the issue have held that this type of incorporated delegation meets this Court's requirements. And let me explain why that's true, even though, again, that's an issue outside the scope of the question presented. We certainly think it would be appropriate for this Court to provide guidance on that issue, but the Court certainly does not have to reach it if it so chooses. What is going on in this case, if you look at the four corners of the arbitration agreement, and I would point the Court in particular to page 58 of the Joint Appendix or to page 8 of our brief, is that the arbitration agreement by its terms incorporates the rules of the American Arbitration Association, and it does so very clearly. That is a quite common arrangement, particularly in commercial arbitrations like the one at issue here. Then, if you take a look at the rules of the American Arbitration Association, those rules, and in particular Rule 7a, clearly give the arbitrator the authority to decide arbitrability. And under this Court's decision in first options, the relevant inquiry is whether or not the parties were willing to be bound by the arbitrator's determination on the issue in question. And so with all due respect to Professor Berman and his amicus brief, the position that he propounds has been rejected by every court of appeals to have considered this issue. And if the Court has any interest in this issue, I would refer the Court to the very thoughtful opinion of the Tenth Circuit in the Belknap case, which discusses this issue in some detail. Again, the Fifth Circuit in the decision under review ultimately did not decide that question. It did discuss that question, and I would respectfully submit that its discussion on that issue was somewhat confused. The Fifth Circuit seemed to think that because there was a substantive carve-out from the scope of arbitration here, that's the very carve-out that's in dispute for actions for injunctive relief, that somehow had a bearing on the validity of the delegation here. But I think with all due respect,
the district court decided on alternative grounds. It wasn't the district court's first decision that this contract did not have a sufficiently clear and unmistakable delegation?
Yes, that is correct. And the Fifth Circuit then discussed the issue but ultimately did not rest on it. And once again, this is a discrete question. It's outside the scope of the question presented. But I would respectfully submit that I think that the law on this issue is quite clear, and that in particular, to the extent that the district court discussed this issue, Justice Ginsburg, its reliance and respondents' reliance on this substantive carve-out cannot be correct. In other words, the respondents' submission below, and really I think respondents' only submission on this issue, was that because there is a carve-out from the scope of arbitration, that somehow defeats the incorporation of the AAA rules, which provide that arbitrability can be decided by the arbitrator. But that is the very issue that the parties agreed for the arbitrator to decide, and I think it would improperly conflate the question of what is subject to arbitration with the question of who decides to say that that defeats arbitrability here.
You just said the parties agreed to have the arbitrator decide this issue. Assume the facts of the Douglas case. Plaintiff or petitioner signed a arbitration agreement over an account, and the account was closed within a year, and years later sues the bank for some malfeasance by a lawyer who took money from a different account or something like it. I think I'm getting the facts of Douglas. And the court and the arbitrator there improperly assumes jurisdiction. There's been a delegation. What are the potential outs for the party who's now been stuck in an arbitration that legally is wholly groundless? The arbitrator made a mistake.
So, Justice Sotomayor, let me address, both that and the related question of what remedies are available to the arbitrator and to the opposing party more generally in the event that a truly frivolous claim of arbitrability is raised.
Exactly.
I think to address your question directly first, I think in a case where an arbitrator reaches an improper conclusion on arbitrability, the remedies, if any, would be those provided for review of arbitral decisions more generally. And as this Court is well aware, there is a very live dispute in the lower courts about the extent to which courts can review the merits of arbitrators' decisions. They can be reviewed for manifest disregard. Issue that's left open. Potential court where an arbitrator reaches a correct decision on ability. I think that the other side points to the Douglas example of ability in the
at least on an arbitration award under the there is no remedy.
Potentially review manifest
if we manifest.
Yes.
Haven't,
but
there's no the act.
No do where an wild conclusion merits of. In other words, ability is in as any other issue properly remitted to the arbitrator. Section 10 of the arbitration.
Do you think that their power
could be, and I think the lower court that have arbitrability, some of them arbitrability is in the same bucket as any other issue that is properly remitted to the arbitrator. Review, if any, would be under Section 10 of the Arbitration Act.
Do you think that it could be the arbitrator exceeding their powers?
Well, it could be, and I think that if you look at the lower courts that have reviewed arbitrability determinations, some of them have located review in exceeds powers in Section 10A4, though even those courts have engaged in pretty deferential review. I think as a practical matter, it's basically the same review as manifest disregard review, and it certainly is not the sort of de novo review that Respondent seems to contemplate.
Can you understand the common sense resistance to the idea that if a party has not agreed to arbitrate a particular issue because it's wholly groundless, there is no way that an arbitrator could, in good faith and without error, reach a conclusion that arbitration was agreed to? It seems counterintuitive to believe that we're sending a party to arbitration to potentially go through the expense of arbitration when something's wholly groundless, and then potentially not to have an avenue of relief when it comes to enforcing the arbitration award.
Justice
That's
Sotomayor.
why, I'm sorry, that's why I think one of the amici said the courts are not understanding that at the core this is always about, have you agreed to arbitrate an issue? And if you haven't, you shouldn't be forced to.
Justice Sotomayor, I'm sorry to have interrupted, but 2 points in response to that. First, I think it's important, to the extent that we're talking about the party's intent, to recognize that the parties intended for the arbitrator to decide arbitrability. There was no carve-out, explicit or implicit, for wholly groundless claims, which is to say that whereas here you have a dispute of this variety, you have one party saying that the claim of arbitrability is wholly groundless. You have the other party saying not only is it not wholly groundless, we believe we have a valid argument about the construction of the carve-out. The parties agreed to have the arbitrator be the decision-maker, and I don't think, with all due respect to Respondent who faints in this direction, that there's any way to reform the incorporated delegation here to create a carve-out for wholly groundless claims, to say that the parties somehow implicitly agreed that the arbitrator would decide arbitrability unless the claim was somehow wholly groundless, or that there would be some preliminary determination by the district court.
Well, why is that, Mr. Shanmugam? I mean, if you look at first options is a case where we said we're not going to treat these delegation clauses in exactly the same way as we treat other clauses. And there was an idea that people don't really think about the question of who decides, and so we're going to hold parties to this higher standard, the clear and unmistakable intent standard. And wouldn't the same kind of argument be true here? That the parties never really considered who was going to decide these groundless claims of arbitrability, or maybe if they did consider it, they would have thought that it was a pretty strange system to send it to an arbitrator just so that the arbitrator could send it back to the court. So that we are going to say that there's a special rule in interpreting these kinds of clauses.
Justice Kagan, there is obviously an interpretive rule that requires clear and unmistakable evidence that the parties intended to delegate the issue. But I would respectfully submit that once you have that evidence, that rule falls out of the equation. And again,
why do you have the evidence? When the model case is this court's rent-a-car decision, and then the clause said the arbitrator, not the court, has exclusive authority. And here we are missing both the arbitrator to the exclusion of the court, and the arbitrator has exclusive authority. It's nothing like that.
I think, Justice Ginsburg, if you take a look at page 946 of this Court's opinion in first options, it focuses on the willingness of the party to be bound by the arbitrator's decision. And I think with all due respect, we have that here. And I think that what you cannot do, I would respectfully submit, is to say that the parties implicitly countenanced a regime where the district court would make a preliminary determination. With respect, Justice Kagan, I think your question assumes that the claim of arbitrability is wholly groundless. That is the very merits dispute between the parties. We believe that we have that the claims at issue are arbitrable, and Respondent disagrees with that. And once that is true, this is a merits issue for the arbitrator to decide.
What's wholly groundless? What's wholly groundless? Is he saying what's wholly groundless is the claim that arbitrability is to be decided by the arbitrator?
No, it's the claim that these substantive claims are subject to arbitration. And that is an issue on which the magistrate judge disagreed. The magistrate judge concluded that we had a plausible construction of this agreement.
Okay, so you say step one, is there clear and unmistakable evidence that an arbitrator is to decide whether a particular matter X is arbitrary? Is that right?
Yes.
And step two, the answer to the first question is yes. They did decide that clearly and unmistakably. And now we see why not send it to them? Or where it's totally groundless, we still won't send it to them. That's this case, right?
That is the regime that Respondent is advocating here.
Yes.
And I would like to say a little bit about why we
I have a question about it.
Sure.
You say, when you get to step 2, once we're there, now there is no wholly groundless exception. Go send it to the arbitrator. Is that right?
That is correct.
Okay. Now, suppose it's really weird. I mean, you want to say no exception at all? He says, my claim here is a Martian told me to do it. Okay? Are you saying no matter what, even if he has to read the word yes in the contract to mean no, never, under no circumstances, is there no exception no matter what?
Yes, and picking up on
Yes, no exception no matter what.
There is no exception no matter what, but there are remedies available where a party makes a truly frivolous claim.
What?
First, it is agreed that the arbitrator has the ability to impose a wide range of sanctions on a party that is making a frivolous argument. Those sanctions are comparable to the sanctions that a court can impose in litigation. And it may also be true.
The arbitrator, by the way, loves Martians.
Well,
so what they're worried about is that they're going to get a bad decision on this ridiculous
But going
claim.
back to the very early days, or the relatively early days of this Court's FAA jurisprudence, this Court made clear in Shearson and Lehman that we presume that arbitrators are fair, impartial decision makers.
Well, they may or may not love Martians, but do you think it's fair to say that they love arbitration? So they're not probably very much inclined to sanction parties who bring arbitrable disputes to them?
They actually do have specific and explicit remedies under their rules for providing for imposing sanctions, including cost and fee shifting and the like. And it may very well be that after an arbitrator makes his or her determination, that a district court would have the ability to impose sanctions under Rule 11 where the requirements of that rule
Well, how
are met.
can it do that? If the court can't even take a peek at the arbitrability question itself, how does the court all of a sudden have the power to sanction a motion to compel?
At least before remitting the issue to arbitration, I think there would be a conflict between Rule 11 and the Arbitration Act if a court were to make a merits determination first. But I think after an arbitrator makes a determination, when the parties are back before the district court, I think the district court would have the ability to make the determination that the petition to compel arbitration was frivolous or broad.
What is the advantage? What is the advantage of this? Because remember step 1. Step 1 is we have to decide, we're a court, we have to decide whether there is a clear and unmistakable commitment to have this kind of matter decided in arbitration. Now, kind of matter. Now, you would have thought if you really have a Martian case, the judge would have found some way not to send it. And he would have said, kind of matter. Well, not the Martian kind of matter. There's no clear and unmistakable commitment to send that kind of matter. In other words, if it's weird enough, you don't have to get beyond step 1. Because you can say there's no commitment to send this kind of matter. And now, what's the difference between that and what they did say, there's no commitment to send a groundless matter?
But the whole point of the principle that the parties can delegate arbitrability to the arbitrator is that the parties can make a decision about who decides. And where the party's intent is sufficiently clear that the arbitrator decides.
Well, it's never sufficiently clear if the matter that they're deciding to arbitrate is a Martian matter. Unless they really said Martians, which I don't think would ever happen. In other words, if it is a totally ridiculous claim, shouldn't you have to find a clear and definite commitment to send a wholly ridiculous matter to the arbitrator?
But that goes to the merits, and wherever you set the bar, the fact remains that it is still a merits determination. And to the extent that this Court is concerned about this as a policy matter, and I would respectfully submit that there is not a lot of evidence to indicate that this is a problem, perhaps not surprisingly, because often the defendants bear the cost of arbitral proceedings. The regime that we are advocating is not only more faithful to the language of the Arbitration Act, it is a much more efficient regime.
What about Section 4 of the Act, which Respondent points to as the front-end equivalent of what you alluded to in response to Justice Sotomayor's, the back-end Section 10 review?
As this Court made
the failure to comply therewith language in particular, which they focus on. What does that mean and what does that do?
Sure. As this Court made clear in Prima Paint, that language limits a court's role in ruling on a petition to compel arbitration to reviewing the making and the performance of the agreement. And here the relevant agreement is the agreement to remit arbitrability to the arbitrator. And there is a failure to comply when the opposing party, the party that does not want arbitration, is resisting arbitration. That is all that is required.
So what work does that language do?
All that it
on
requires.
performance. Give me an example of when that would have some effect, if there is one.
Well, I think that all it requires a court to do, and this is a pretty minimal function, is to determine that you have one party that wants arbitration and another party that does not.
That's what I thought you'd say, and that means, in essence, I think that language in the statute does no work.
Well, there has to still be a dispute, which is to say you've got to have one party.
That's covered by the beginning of the Section 4, though.
I don't think so. I mean, I think that is the relevant failure to comply.
A party aggrieved by the alleged failure or refusal to arbitrate. I'm just trying to figure out what failure to comply therewith.
I think both sides agree that those two things are essentially reinforcing, which is to say that when you have a party that resists arbitration, the moving party is aggrieved. And I think that Respondent recognizes in a footnote in its brief that aggrieved does no independent work beyond that. But I do think that the regime that we're advocating is a more efficient regime precisely because under Respondent's regime, a district court is supposedly making this threshold determination on whether or not the claim of arbitrability is wholly groundless. If a district court concludes that the claim is not wholly groundless, presumably the issue would then go to the arbitrator to make a plenary determination on that issue. And if the district court determines that the claim is wholly groundless, there will be appeals as of right immediately under Section 16 of the Arbitration Act. And that will lead to the very inefficiency that we see in this case. This case is certainly an outlier because it has taken so long. But we are now 6 years down the road still litigating the issue of arbitrability.
Oh, but that was the court's, the court to decide whether the motion was for the magistrate judge to reconsider or for the district court to review.
That explains 3 of the 6 years of the delay, Justice Ginsburg, but I really don't think it can be reasonably disputed that if the issue of arbitrability had gone to the arbitrator in the first instance, as it should have, that we probably would be entirely done with this case. And, of course, our fundamental submission is that there is simply no footing in the text of the Arbitration Act for this exception. To the extent that the Court has questions about the delegation in this case, that is a discrete question that the Court need not reach here. And so we submit that on the question presented, the answer is quite simple. The FAA does not permit this exception, and therefore the judgment should be vacated. I'll reserve the balance of my time for rebuttal.
Thank you, counsel. Mr. Geiser?
Thank you, Mr. Chief Justice, and may it please the Court. Petitioner's position is at odds with the FAA's plain language and the party's obvious intent. Under Section 4 of the
Your position is contrary to rent-to-center.
I don't believe so, Your Honor.
So explain it to me, because I think rent-to-center said that language is limited to, was there an agreement between the parties, and was there a delegation? And if there is, don't look to the merits. I don't see how determining whether something is wholly groundless is anything but a merits determination.
Well, Your Honor, it's what type of merits determination. Section 4's plain text authorizes the courts and, in fact, instructs them to have a gatekeeping function in looking at the merits of whether there's a failure to comply with the arbitration agreement. It says nothing at all about the failure to file a legitimate claim on the merits. So it draws a textual—
I'm sorry. Was there an agreement? There was an agreement.
But Rent-A-Center, again, what they were talking about in that case is they're saying that if the underlying merits is frivolous, the underlying merits of the case, the actual lawsuit.
The Rent-A-Center didn't say that at all. Rent-A-Center said don't look at the merits at all. It didn't carve out a particular form of the merits.
Well, I don't think Rent-A-Center, though, was saying that if there's only one possible outcome, then you should send it to the arbitrator anyway. And, in fact, that would be inconsistent with what this Court did in Stolt-Nielsen. In Stolt-Nielsen, the parties expressly agreed that the arbitrator would decide if there's class arbitration. And the court said the arbitrator applied the wrong analysis. And it did not send the case back to the arbitrator to do again. It said there is only one possible outcome, and so proceeded to decide the issue on its own. And that's consistent with general legal principles. If there is an absolutely futile claim, it makes absolutely no sense, there's no conceivable possibility that the arbitrator will say that this case belongs in arbitration. There's not a bona fide dispute. There's no point to sending it to the arbitrator.
Well, that's the problem and that's the problem with my prior suggestion, is really what Justice Sotomayor says. Once you look beyond the first question, did the parties agree to send this kind of dispute to arbitration? And then you start getting to the second question. Did they mean this kind, that kind? You're really deciding arbitrability. Courts will decide different things. Everybody will start making their arbitration argument. And even though it'll save time in a handful of cases, time will be lost overall. So read it for what it says. It hands the decision to the arbitrator to make the arbitrability decision. What's wrong with that?
There are a number of problems with that, Justice Breyer. The first is a textual problem. If there's no chance that the arbitrator will conclude, it's the Martian example, that this case is subject to arbitration, there's no possible failure to comply with the arbitration agreement. And that's what Section 4 says. The court, before it can compel arbitration, it has to conclude there's a failure to comply. And if they look and there is no conceivable universe where this case belongs in arbitration, there's not a failure to arbitrate by filing in court. No one agreed to that. It's also inconsistent with the party's obvious intent.
But doesn't that depend on the nature of the agreement as to arbitrability? What did the parties agree to have the arbitrator decide? Suppose you have an agreement that says the arbitrator has exclusive authority to decide all questions of arbitrability, regardless of whether the claim of arbitrability has any merit whatsoever. What would you say then?
I think that would be a highly unusual agreement.
Yeah, but what would you say?
If the party said that, then I think you would have a failure to comply with that agreement. But the reason we don't see that is because no one agrees to be subjected to a needless and needlessly expensive gateway arbitration.
But that's not the question that's before us. That's the question of the interpretation of this contract and the scope of what was delegated to the arbitrator.
Well, but the scope of what was delegated, the question here is, did the parties actually agree at the outset, is there a clear and unmistakable showing that they intended to have an arbitrator decide a wholly groundless claim that has only one possible answer?
Well, I thought the question we agreed to take was whether there's a wholly groundless exception when the parties have agreed that arbitrability will be decided by the arbitrator.
Well, but I think there are two different things here, Justice Alito. One is there a general delegation clause, which, again, wasn't even found in this case. It comes to the Court assuming that there is one. And then the second is, if there is a general delegation clause, it's just here is incorporating the AAA rules, which, as Professor Berman pointed out, is a pretty tenuous hook to satisfy a clear and unmistakable standard. Did the parties, when they said nothing else about it, really intend to be subjected to frivolous arbitration claims?
Mr. Geiser, the problem is that you're taking the position here that this was wholly groundless, to consider a mixed injunctive relief and damages claim as being covered by this arbitration award. The other side makes a very compelling argument that, no, there's actually a ground to say that injunctive relief goes to the court, but damages go to arbitrators. And when we have mixed claims, most courts will either send the matter to arbitration and stay the injunctive relief until the arbitration's over. If they determine that both can go simultaneously, they do it. But there are plenty of cases with mixed questions that courts handle all the time. My difficulty is that I don't know where to draw that line. I don't know where what's wholly frivolous to you may not be to someone else. And if there's been a true delegation, why shouldn't that go to the arbitrator? Don't go to the facts of this case. Let's assume a clear delegation, because I know you're making arguments about the ABA, but we didn't grant cert on that.
I agree. Let's assume a clear delegation, but let's also assume a completely frivolous, baseless, maybe even abusive claim.
No. Are you claiming, because you're arguing that this case is wholly groundless, because that's the ground that arbitration was not ordered by the court below. This is the quintessential case where most of these cases are on the margin. And I've actually gone and had the library do research. The number of wholly groundless cases is very small. So, mistakes are made even by judges. So the fact that the 4 or 5 arbitrators who make a mistake, I don't know if that's statistically different than judges making mistakes.
Your Honor, the wholly groundless doctrine is a very modest inquiry. All you need to do to satisfy, in respect to my friend, it is not asking the court to decide the arbitrability determination. It's asking them to decide, is there a dispute over arbitrability, a bona fide dispute?
But the court has to decide wholly groundless. So where do you draw the line between merely incorrect, groundless, wholly groundless?
Good question.
I think where the line is drawn is the way the courts of appeals have drawn it. Is there a bona fide dispute? If a court cannot identify any plausible or legitimate argument, it can be exceedingly weak, then it goes to the arbitrator because that's what the parties agree.
That's my problem in this case.
Well, but again, my friend, though...
It may be extremely weak, and I'm not sure that's true, but...
Your Honor, respectfully, though, petitioners sought review on one question, not two. They took it was their strategy. They did an all-or-nothing categorical attack, saying there is no wholly groundless doctrine under any circumstances. They could have added a second question, saying if there is a wholly groundless doctrine, we don't think it was met here. But they didn't raise that question.
You seem you're just slicing the bologna a little thin. It's not just groundless; it's wholly groundless. And when you say, "Well, what's wholly groundless?" you say, "Well, there's no bona fide dispute." The answers about what the content of it is just sort of substitute one adjective for another, which I think highlights the problem, which is that, do you think there's a difference between groundless and wholly groundless?
I think that the difference is there a legitimate or plausible argument? Is there any argument on the other side of the ledger? And if there is, then the courts compel arbitration.
So what standard should we say, wholly groundless or no bona fide dispute?
I would say if there's not a bona fide dispute, then it goes to the arbitrator. I think that effectively, even though courts have used different articulations, that's where each standard points to.
But what does even that mean? Clearly there's a bona fide dispute when two parties are litigating all the way to the United States Supreme Court.
Well,
right? And so I know it's a small exception today, but the experience of this Court has been when it creates small exceptions, they tend to become larger ones with time. And the whole point of arbitration, of course, is to try and streamline things. And having litigation all the way up and down the federal system over wholly groundless, only to wind up in arbitration ultimately seems highly inefficient. And isn't your real complaint here the first one, Justice Breyer's, and that there's just maybe a really good argument that clear and unmistakable proof doesn't exist in this case of a desire to go to arbitration and have the arbitrator decide arbitrability. And why does that take care of 90% of these kinds of cases?
It may take care of a lot of them, and it will take care of it in this case. The Fifth Circuit all but concluded that
So why do we need to go down the bologna slicing road, to mix my metaphors?
Well, we suggested that the Court not grant review precisely because this is not a good vehicle for it, because there's not a clear and unmistakable showing in any possible way. But
so are you now saying we don't need to answer the question presented, and you give up and go back to the Court of Appeals on the first one?
Absolutely not.
I didn't think so.
Absolutely not. Now, and just to show how little of a problem this causes in practice, this doctrine has existed for decades in multiple circuits. And it's rarely invoked because courts can understand the difference between something that is like a Rule 11 sanctionable argument and something that's a legitimate argument. And they've applied it faithfully. The Federal Circuit in Qualcomm, the Fifth Circuit in Kubala, they've made it absolutely clear. You do not invade the province of the arbitrator. You make sure that there is literally no argument that supports it. Now, maybe you disagree looking at the facts of this case, whether the standard was met. But the fact is that we didn't brief this because it's outside the question presented. The Texas district judge looked at it. 3 Fifth Circuit judges looked at it. And they all said there is no possible scenario where this will end up in arbitration.
We have a magistrate judge who disagreed. And we have other courts in other circuits, I'll bet. But we have other courts who have read it exactly the way they read it. And so it can't be wholly frivolous when you have so many people split on an issue.
Well, no, Your Honor. And just to be very clear on two things. The magistrate judge recognized that petitioner's construction of the actual language of the agreement was problematic. That's at page 41A of the petition appendix. It said problematic. It rewrote the agreement to match what the magistrate judge thought would be a better arbitration clause. That's exactly what this Court has said that arbitrators can't do, and I don't see any license for a magistrate judge to be able to do it either. You have to apply the agreement as written. And for the other circuits that have looked at other clauses and say we can divide it up between injunctive relief and cases on the merits, those involved very different arbitration clauses. The language of those clauses were written in very different terms. They typically divided up one general delegation where everything goes to the arbitrator, and then in a separate section or a separate sentence at least, it carved out specific claims that sought injunctive relief. Here you have a parenthetical that says that if it's an action, not a claim, but an action seeking injunctive relief, it's excluded.
Well, what injunctive relief does Archer seek? We're told that what Archer wants most of all is money, damages.
Well, and the courts could have, or the parties could have written, at least the ones that had the arbitration clause, could have written this to say that the predominant relief is damages. It goes to the arbitrator. That's not what they wrote.
But what kind of injunctive relief? Let's take this down to the ground.
Sure. They're seeking an injunction of anti-competitive conduct that has been investigated now by multiple state and federal agencies and that we allege is ongoing today. So what they'd like to have happen is the anti-competitive conduct to stop. Now, if that goes to the arbitrator, that will multiply proceedings because an arbitrator can't enforce their own award. They don't have an army. You need to get an award from the arbitrator saying we'll grant an injunction and get that enforced in court, where surely there will be more litigation in court. So it makes perfectly good sense that parties thinking in advance that they might need injunctive relief, they would not want to include to arbitration an action seeking injunctive relief. But to bring us back to the actual text of the statute.
On the text of the statute, you hang almost everything on the failure to comply therewith language, and you heard Mr. Shanmugam's response to that that's very much a minimal bar that is merely designed to ensure that someone's opposing the referral or opposing arbitration. What's your response to him?
Respectfully, I think he's mistaken. When the plain language of the statute, which is imposing a direct gatekeeping function on the court, say they have to be satisfied there's been a failure to comply with the arbitration agreement. So from a common sense perspective, does anyone think that you failed to comply with an arbitration agreement when the only conceivable outcome is the case belongs in court? It's effectively like saying a party has to go to the arbitrator and seek pre-clearance before they can file their claim, even if it's the Martian example, where there's no conceivable chance that the arbitrator, if they're genuinely construing the agreement, will say this belongs in arbitration. And that respectively just makes no sense. And especially makes no sense looking at the statutory design. Congress under Section 10, and we do think Section 10 provides a back-end safeguard here, that if an arbitrator takes the Martian case and they absolutely exceed their powers, they've adjudicated a dispute that the parties did not grant authority for the arbitrator to resolve, that would be in excess of authority. It makes no sense when Congress has that specific substantive check on the back end. They've authorized the same judges to read the same agreement and make the same wholly groundless type determination that they say, let's just do it on the back end and not on the front end before we can save this huge and colossal waste of time and resources.
Just follow me here is that Professor Berman, I thought, was writing an amicus brief on your side, which says there isn't a clear and unmistakable commitment to arbitration. But is that issue in front of us?
I think it's assumed in this case that there is, even though
there is. So we'd say that point he made might be a good point, but that's not in the case. So it's not in the case that there is, whether there is a clear and unmistakable arbitration. It's not in the case whether this was wholly groundless. And we're taking this case assuming that there is such a thing as the unmistakable and assuming also that it is wholly groundless. Then is there an exception for the wholly groundless? So I'm not making an argument. I just want to be sure I'm right.
That is, in fact, what the Court, I believe, is doing. And we would warmly...
Pretty theoretical, and that's an argument.
We would warmly invite a dig if the Court would like to dig the case. But at the same time, though, we do think there is, in fact, a wholly groundless doctrine, just as there has been one for decades in the lower courts without any meaningful frustration of legitimate rights to arbitrate.
Mr. Geiser, can I go back to Justice Kavanaugh's textual question? Because when I stare at this language, the failure to comply therewith language, it seems to me I can read it two ways, neither of which is yours. So the first way is Mr. Shanmugam's minimalist way, doesn't mean very much of anything at all. The second way suggests that we've gone wrong in prior cases. It's the maximalist approach, which is what this language was meant to do was assign arbitrability issues to the courts. But we've pretty much we've gone by that understanding of the language. What I can't understand is how you can read the language to create this halfway house position.
Sure. And Justice Kagan, first of all, I do think that actually the most faithful interpretation of this text is that it does assign to the courts the responsibility to decide the gateway issue. But that ship is somewhat sailed.
You can't do that.
But I'm sorry?
Keep going.
The ship is sailed. We're agreeing that the ship is sailed.
But I do think, though, just if you read the language sensibly, both looking at the actual text and looking at Section 10, understanding that there will be this review on the back end, it only makes sense to say that there's not a failure to comply with an arbitration agreement if what the parties agreed is that if there's a legitimate dispute, there's a bona fide dispute, it goes to the arbitrator. If there's not a bona fide dispute, then there's no failure to comply by filing it in court. And I do think that you can read that into the language of an ordinary agreement. Looking at all the contracts and all the cases that came up in this, I didn't see a single example where people said, we'll have a delegation provision, but no frivolous claims or no sham allegations. No one writes that into an agreement because it's presumed.
But you seem to agree with Justice Kagan, I think, that the statute doesn't, most naturally read, create a wholly groundless exception with that language. It may have suggested the court should decide questions of arbitrability. So the court's rejected that. So why create I guess I'm repeating Justice Kagan's question, but why create this new thing out of language that was not designed to do that?
Well, Justice Kavanaugh, I don't think it's new at all. I think that it's very hard to say.
It's new in the statute is what I'm saying, in the sense that you had an all-or-nothing question, I think, with the statutory language, as Justice Kagan said, and the court decided that.
Well, I think there are two ways to look at it, and one is a statutory hook, which I still do think is the best way to read this language. It's very hard to understand how something is a failure to comply with an arbitration agreement if the arbitration agreement is saying if there's a bona fide dispute over arbitrability, then it goes to the arbitrator. If there's not a bona fide dispute over arbitrability, then you don't fail to comply by filing it in court. So it is, in fact, I think the wholly groundless doctrine that it's tapping on an intuition that's already there. It's just giving this language some sort of reading that makes sense and that's consistent with the party's intent.
But that goes, again, to the interpretation of the delegation of arbitrability. As I understand your argument, you're saying that implicit in any provision of a contract that says arbitrability is for the arbitrator, there's the exception for this type of dispute. That's the argument, right?
That is part of the argument, Your Honor, and the reason I think it's correct is that no one anticipates being dragged into an absolutely frivolous dispute. Good faith is inherent in every contract. That's a matter of North Carolina contract law, which is what this agreement is subjected to, and general contract principles.
But is that generally true when parties agree by contract on a particular decision maker? What if it's a forum selection clause? Is there an exception to that for wholly groundless disputes?
No, I think a forum selection clause that would be slightly different because someone has to adjudicate the underlying merits, whether it's this judge or a judge in a different district. That's not true, though, with a wholly groundless arbitration demand. This is generating a pointless process. This is what happens when you file a wholly groundless arbitration demand. Either it goes to the arbitrator, who wastes time and money, and it's far more than my friend suggests. It can take weeks or months, and it can take tens of thousands of dollars to get this predicate threshold issue resolved. And then they send it right back to the court. Or even worse, they make a catastrophic error, and sometimes people make mistakes. They keep the case, and then the court vacates it at the end of the day under Section 10. And respectfully, that is not a sensible system. And to the extent my friend suggests that ways to police that are the arbitrator could sanction.
But is this a sensible system where, even though we only have 5 cases over a long period of time in which courts have denied arbitration on wholly frivolous grounds, we're now inviting this fight in every motion to compel arbitration? And that itself will multiply expenses, maybe not in your individual case, but as a burden on courts.
No.
So it's not clear to me that your solution is more efficient in a meaningful way.
I think our solution is far more efficient, Your Honor, and if I could explain why.
Only if you win.
Well, if we win.
If you win in court.
Well, no, I think plaintiffs have an incentive to have their cases adjudicated. They're not the ones that are trying to invite protracted side litigation over issues. It's only the plaintiffs who actually think the arbitration demand is wholly groundless that will spend the resources to resist on that level. And I also think it's far more efficient for the court to decide this than the arbitrator. The court already has to look at the arbitration clause. It has to do that. Whatever Section 4 means, we can all agree that it does impose a gatekeeping function. The courts do have to look at something. So they're looking at the dispute already. All they need to do to resolve the wholly groundless inquiry is say, is there a dispute? They don't need to decide it. They're not resolving arbitrability. They say, is there any legitimate argument here that any reasoned decision maker could credit? If they identify that argument, they send it to the arbitrator. That is far more efficient than asking the parties to initiate a needless and needlessly expensive gateway arbitration when everyone knows the only two possible outcomes is they send it right back so you can start over in court months later, possibly tens of thousands of dollars in the hole, or months or years later if the arbitrator makes a mistake and keeps it. So I don't think that is an efficient system. And I think, again, this doctrine has existed in courts, multiple courts, for decades without any noticeable effect on parties' legitimate arbitration rights.
So could I go back beyond your saying it's not an efficient system? Are you saying essentially that the basis for this rule is that we don't believe that a delegation clause includes this, that we don't believe that the parties intended for a general delegation clause to include these kinds of groundless questions? Is that basically the idea?
That is
a contractual idea.
Exactly. That is a core of the idea.
Yeah. So I mean, that might be a rule of contract interpretation here, but you're trying to say that the FAA, specifically Section 4, sets up as a kind of substantive interpretive rule that we're going to interpret these contracts in a certain way. And that seems like a strange thing for us to think about the FAA.
Oh, I don't think that's strange at all, Your Honor. In First Options and in Oxford or in Stolt-Nielsen, the Court specifically says that it crafts interpretive rules in the setting to match the party's likely intent. So if the Court thinks that when parties are silent about what do you do with a wholly groundless, frivolous dispute, and again, if the doctrine, this is an all-or-nothing challenge to it. So the Court has to think, what about the truly frivolous arbitration demand? And I think it's perfectly sensible to say that parties did not agree to have non-bona fide disputes sent to an arbitrator. I don't think that's a reasonable proposition. Again, I have not seen a single contract that says we reserve wholly frivolous, abusive arbitration demands.
Well, but you phrase it that way, but you could phrase it differently. What if there's a party that has historically not done well in court, and whatever comes up, they say, I don't want a court to do it, I want an arbitrator to do it. What's wrong with that?
I think if the party is as clear and unmistakable in saying that even if the dispute has absolutely no conceivable merit and everyone knows it's going to be back in court whether the parties like it or not, then if they make that sufficiently clear, then debatably there's a failure under Section 4.
There's a work contract, lawyer, labor. One of them says, I'll tell you what I want arbitrated. Who owns Crimea? Okay, what's the judge supposed to do? The contract has nothing to do with this. So what's the judge supposed to do?
I think if it's a wholly groundless.
It has nothing to do with this contract. You want something arbitrated, nothing to do with it.
I think the answer, if the court looks at it and says there's nothing for the arbitrator to do, then there's not a failure to comply by not filing an arbitration demand.
Okay, so that's the basis of this groundless business. Okay, so he has this. I have the same question. Okay.
So I think, and that's also consistent just with general litigation norms. My friend suggests effectively that the FAA carves an exception to Rule 11 principles, and I don't see that anywhere in the text of the FAA. On the contrary, this Court construes the FAA as creating sort of an equal treatment rule. All arbitration agreements are treated just the same as any other agreement. And normally when a party files a frivolous and abusive claim in court, they're sanctioned. They don't win. And I don't think it makes any sense to say that someone can file a frivolous claim then you reward the claim, you send it to the arbitrator, and then after the arbitrator gets done saying, yeah, that was frivolous, then you sanction them under Rule 11.
If we don't accept your argument, can you tell us there are many, many open questions in this case, right?
There are many open questions in this case.
So that the Fifth Circuit didn't decide.
That's correct. It comes to the court where the Fifth Circuit it almost decided. It explained why petitioner's argument that there is a delegation clause was wrong, but then didn't actually enter a holding on that, which, again, is why we think that, in a way, this is an academic decision in this particular case. Again, it's outside the question presented, so we didn't brief the substance of that.
It's not academic because our answer has a consequence. If we agree with him that there is no statutory provision for wholly groundless exceptions, then all the other questions have to go back and be actually answered.
Yes. No, I'm not suggesting that there's not jurisdiction to resolve the question. I'm just saying that in this case, it is highly unlikely to have any effect on the ultimate outcome.
Well, that's only because you intend to win all the other questions. But
that's certainly
I can't tell you that.
Yeah. But again, though, the way it comes to the court is it's saying is even for the most frivolous and abusive arbitration demand imaginable, if there is a delegation clause, are the courts actually powerless where they have their only option is to send it to the arbitrator where they already know the answer? And that's inconsistent with what this court did in Stolt-Nielsen. Stolt-Nielsen specifically looked, and this is at page 676 and 677 of the court's opinion, and said if there is only one possible outcome, even where the parties, as they did in that case, expressly agreed that this is a determination for the arbitrator, then you do not send it back to the arbitrator because it's pointless. You decide it yourself. And that's exactly what the wholly groundless doctrine is doing, and it's doing it sensibly on the front end. When you look at an arbitration demand, and you can either say the parties didn't clearly unmistakably intend, when you have a frivolous dispute that has nothing at all to do with the contract, to send it to the arbitrator. It's enforcing the party's intent. I think it's consistent with Section 4. If the Court has no further questions.
Thank you, counsel. 4 minutes, Mr. Shanmugam.
Thank you, Mr. Chief Justice. Respondent's argument today really assumes the answer to the inquiry when Respondent argues that the parties never would have wanted to arbitrate wholly groundless claims of arbitrability. The exact same argument could be made where the underlying substantive claims are frivolous. The argument could be made that the parties would never have wanted for that to go to the arbitrator and would have instead wanted a court to short-circuit that inquiry. But this Court in AT&T Technologies made clear that even if a court thinks that a claim is not arguable, it is still obligated to send that claim to arbitration where the parties have so intended.
It is a little bit different, though, Mr. Shanmugam, because in the case that you said, if it's really groundless, you expect that the arbitrator will get rid of it just as fast as the court will get rid of it. What makes this case a little bit different from that is that here all the arbitrator is going to do is to send it back to the court. And you might think, well, what sense does that make?
But the arbitrator will make that determination, presumably efficiently, will do so at the outset of the proceedings. And, of course, we're assuming here that the parties contracted to have the arbitrator make that determination, presumably for the same reason that parties agree to have arbitrators make merits determinations, because they conclude that that will be a more efficient and cheaper way of resolving the relevant issue. And Respondent has no answer for Justice Sotomayor's question about this Court's decision in Renner Center, which provides that where the parties have remitted the issue of arbitrability to the arbitrator, it should be treated just like any other issue. And what Respondent is asking this Court to do is to allow courts to make merits determinations on the issue of arbitrability even in the face of a delegation. And that brings me,
for sake of argument only, hypothetically, that we disagree with you. There in fact can be a wholly groundless ground, pardon the pun. Do you lose under your question presented? Assuming that I thought, again, presuming only, that you had an arguable claim.
We continue to believe that we have a valid claim of arbitrability and certainly not a wholly groundless one. And if this Court vacates and this case gets to the arbitrator on that issue, we will make that argument. And I would note parenthetically.
But you don't under the question presented if we disagree with you.
We didn't present a question concerning the application of the wholly groundless exception. To be sure, that's obviously a case-specific determination. But I do think that this case illustrates the danger of the wholly groundless exception. There would be a dangerous rigorous pliability to that standard, regardless of what words this Court puts on a page. And this case illustrates that. And so in addition to the inefficiency of this standard, I would point to that pliability as reasons why this Court, as a policy matter, should not adopt this exception, an exception that, as you point out, Justice Sotomayor, has been applied in only a very small number of cases since the Federal Circuit of all people first recognized this exception about a decade ago. And so it simply would not be worth the candle to filter out the truly frivolous claims, particularly where there are remedies available, sanctions remedies available for Justice Breyer's Crimea hypothetical and any other hypothetical one might imagine. And I think it's very hard to look at the
law. I mean, normally in the law, when a judge has something frivolous, he says so. So we have your thing on the one side. It's like a forum selection clause. But on the other side is a natural reluctance when you have something absolutely frivolous, not to say.
There are certainly cases in the law.
It's
more
not just
generally.
arbitration. It's all over the place.
I recognize that, for instance, in the context of administrative law, there are cases that stand for the proposition that where an administrative agency concludes that it would be futile to have a hearing, the agency has the power not to hold the hearing. But this case is different from any of those cases because what Respondent is arguing is that where the parties have agreed to have one decision-maker make a determination, another decision-maker has the power to short-circuit that determination. And after all, the fundamental policy of the FAA is to enforce arbitration agreements according to their terms. The wholly groundless exception would create a way around that policy, and we would respectfully submit that the judgment should therefore be vacated.
Thank you, counsel. The case is submitted. In case number 17-1272, Henry Schein versus Archer and White Sales, Incorporated, Justice Kavanaugh has the opinion of the Court.
This is a case about arbitration. In 1925, Congress passed and President Coolidge signed the Federal Arbitration Act. Under the Act, arbitration is a matter of contract, and courts must enforce arbitration contracts according to their terms. Applying the Act, we have held that parties may agree to have an arbitrator decide not only the merits of a particular dispute, but also gateway questions of arbitrability, such as whether the parties' agreement covers a particular controversy. Even when the parties' contract delegates the threshold arbitrability question to an arbitrator, the Fifth Circuit, in this case, and some other courts of appeals have determined that the court, rather than an arbitrator, should decide the threshold arbitrability question if, under the contract, the argument for arbitration is wholly groundless. Those courts have reasoned that the wholly groundless exception enables courts to block frivolous attempts to transfer disputes from the court system to arbitration. The question here is whether the wholly groundless exception is consistent with the text of the Act and with our precedent. We conclude that it is not. We must interpret the Act as written, and the Act in turn requires that we interpret the contract as written. When the party's contract delegates the arbitrability question to an arbitrator, a court may not override the contract. In those circumstances, a court possesses no power to decide the arbitrability issue. That conclusion follows not only from the text of the Act, but also from precedent. We have held that a court may not rule on the potential merits of the underlying claim that is assigned by contract to an arbitrator, even if the claim appears to the court to be frivolous. That principle applies with equal force to the threshold issue of arbitrability. Just as a court may not decide a merits question that the parties have delegated to an arbitrator, a court may not decide an arbitrability question that the parties have delegated to an arbitrator. In an attempt to overcome the statutory text in this Court's cases, the party opposing arbitration here, a business known as Archer and White, advances several arguments. In cases like this, as Archer and White sees it, the arbitrator will inevitably conclude that the dispute is not subject to arbitration and then send the case back to the district court. So why waste the time and money? The short answer is that the Act contains no wholly groundless exception, and we may not engraft our own exceptions onto the statutory text. In addition, contrary to Archer and White's claim, it is doubtful that the wholly groundless exception would save time and money systemically, even if it might do so in some individual cases. Archer and White assumes that it is easy to tell when an argument for arbitration of a particular dispute is wholly groundless. We are dubious. The exception would inevitably spark collateral litigation over whether a seemingly unmeritorious argument for arbitration is wholly groundless as opposed to groundless. We see no reason to create such a time-consuming sideshow. Archer and White further assumes that an arbitrator would reject arbitration in those cases where a judge would conclude that the argument for arbitration is wholly groundless. Not always. After all, an arbitrator might hold a different view of the arbitrability issue than a court does, even if the court finds the answer obvious. It is not unheard of for one fair-minded adjudicator to think a decision is obvious in one direction, but for another fair-minded adjudicator to decide the matter the other way. In sum, we reject the wholly groundless exception. The exception confuses the question of who decides arbitrability with the separate question of who prevails on arbitrability. When the party's contract delegates the arbitrability question to an arbitrator, the courts must respect the party's decision as embodied in the contract. We express no view about whether the contract at issue in this case, in fact, delegated the arbitrability question to an arbitrator. The Court of Appeals did not decide that issue. Under our cases, courts should not assume that the parties agreed to arbitrate arbitrability unless there is clear and unmistakable evidence that they did so. On remand, the Court of Appeals may address that issue in the first instance, as well as other arguments that Archer and White has properly preserved. The judgment of the Court of Appeals for the Fifth Circuit is vacated, and the case is remanded for further proceedings consistent with our opinion. Our opinion is unanimous.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in Case 19-511, Facebook versus Duguid. Mr. Clement?
Mr. Chief Justice, and may it please the Court. The TCPA defines an automatic telephone dialing system as equipment with the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such number. The statute prohibits calls using an ATDS to emergency and cellular lines, but not to residential lines. Under well-established rules of grammar and statutory construction, the entire phrase, telephone numbers to be called using a random or sequential number generator, applies to both disjunctive verbs, store or produce. The contrary reading covers any device that can store and dial numbers, even without the use of a random or sequential number generator. That reading creates a statute of impossible breadth and a fundamental mismatch between the ATDS definition and the targeted ATDS prohibitions. Under ordinary rules of grammar, a restrictive modifier that follows two disjunctive verbs modifies both, not just the second one. Three features of the statutory text here reinforce that conclusion. First, the punctuation. The modifying phrase here is set off by a comma, which indicates that the phrase modifies both verbs. Second, the shared direct object. The direct object that follows produce, telephone numbers to be called, conceitedly applies equally to store as well as produce. Having some, but not all, of the text that follows produce refer back to store requires a significant judicial rewrite. Third, the scope of the ATDS prohibitions. They do not prevent ATDS calls to the residential landlines used by most Americans in 1991. Instead, they target only the specialized lines, emergency, cellular, and multiple business lines, that were distinctly vulnerable to random and sequential dialing. That limited scope makes sense as a targeted response to the problems of random or sequential dialing. But if Congress were really aiming at annoying calls from devices that could store and dial numbers, its failure to protect the home front would be inexplicable.
Mr. Clement, your friend on the other side says that we ought to look to the sense of the passage and not to rules of syntax. I know you have a dispute about what the sense of the passage is, but as a general matter, he's right, isn't he? I mean, the drafters here weren't following the rule of redondo singular singulus or diagramming these sentences. So why should we focus on syntax to the extent that I think both parties do?
Well, Your Honor, I think because the other way lies madness, with all due respect. I mean, I think if one deviates from the rules of sort of ordinary grammar and statutory construction, then there becomes so much play in the joints that you essentially empower the judiciary to rewrite statutes. And with all respect to my friends on the other side, I think that's really what they invite you to do here. I think Congress targeted a very specific problem in this provision, a problem that was prevalent in 1991. I think it was successful in eradicating that specific technology, and my friend would like to use the synesis, or the sense of the statute, to repurpose the statutory prohibition to address more modern ills.
Well, it's clear that they didn't have in mind the modern ills, as you say, and the modern ills, at least according to your friend, would lead to a disaster if his interpretation weren't adopted. Is that something we should consider at all?
I don't think it's something you should really consider, and I think it gives too little credence to Congress's own ability to address these problems in an ongoing way. As recently as 2019, Congress passed another statute addressed to the problem of excessive telemarketing calls. One of the things that act did is to try to create a process where the technology we use in our home phones and our cellular phones would itself block these kind of unwanted calls.
Thank you, Counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Clement, I know this isn't central to your case, but but I am interested in why a text message is considered a call TCPA?
Well, Justice Thomas, I actually think that's an excellent question. And I think it is another way in which the courts have essentially updated the statute to keep up with the times. And it's not at all clear that a statute that was directed not just at calls, but also in particular at artificial or pre-recorded voice calls is really sensibly applied to texts at all. And if one were to hold that the statute were limited to actual voice calls and not to texts, that would be an alternative route for ruling in our favor in this case. The one other thing I would point to, Justice Thomas, is there is an amicus brief by the Washington Legal Foundation that addresses this issue specifically. And what they point out is that in more recent statutes, when Congress addresses calls and texts, they do so either conjunctively or disjunctively, but I think that gives real evidence to the fact that one doesn't naturally talk about a text as a call, but rather one talks about either calls I've received on my phone or texts I've received.
When we talk about a number generator under the TCPA, are we talking about a device as a number generator or a process? It would seem that perhaps it would make more sense it would be a device, but what's your thought on that?
Justice Thomas, I think the statute's most likely read as talking about a process that is part of overall equipment. So I think they may have had in mind a computer program that would be part of the overall equipment that's used to store or produce a number using the random or sequential number generator and then to dial that number.
Thank you, counsel. Justice Breyer?
My only question was was in light of your answer to the Chief Justice. I think you say in your brief, and it seems right to me, is that if we take your opponent's definition, then it would be unlawful for a person to use a cell phone, yes, that stores numbers, like an emergency hospital number, to make a call to the emergency line of the hospital. Now, that I think you say something like that. Is that right?
That's right, Justice Breyer.
And were you telling the Chief Justice that's irrelevant?
No, I didn't mean to tell the Chief Justice that was irrelevant. I think that the scope of the statute...
Wouldn't you say it's fairly important? I mean, it produces a very peculiar or weird result. Does have something to do with interpretation, doesn't it?
Oh, absolutely. All I was responding to is the idea that rather than looking at the results produced by the actual words and their syntax, whether we start sort of creeping into this concept of synesis, which, I mean, maybe, it's sort of en vogue in sort of grammarian circles, but I really don't think that's something that's featured in this court's cases. And I think the ordinary...
I'm making a general point that both consequences and purposes and text are all relevant. And in this case, you have a pretty strong claim, in my opinion, and I'll ask your colleague, your friend, you have a pretty strong case on the consequences and purposes.
Well, obviously, Justice Breyer, there's a range of views on this court as to how much one looks beyond the text to sort of context and consequences. I think happily here, I think text, context, and consequences all point in favor of our proposed construction of the text.
I realize you. I realize you. Thank you.
Justice Alito? Justice Alito?
Mr. Clement, the statutory phrase that we have to interpret in this case has a structure that is fairly common. It lists two activities, storing or producing telephone numbers, followed by a modifying phrase, using a random or sequential number generator. People make statements like that all the time. And you know what? Those who hear them or read them understand what they mean without looking at treatises on grammar, syntax, usage, or interpretation. And the way they do that is to ask what makes sense. I could give you lots of examples, but I have very little time for questioning. So they ask about the sense of it before they get to all this arcane stuff. So the question that jumps out here is this. Does it make any sense to speak about storing a list of telephone numbers using a random or sequential number generator? Now, the best answer I can find in the briefs on your side is that there were systems that produced lists of numbers using such a generator and then stored them. But unless you can explain how a generator was used in the very process of storing the numbers, I think you have a problem.
So, Justice Alito, two quick things on that. One is, I do think readers of language have an advantage over listeners, which is they can look for the punctuation, and I do think the punctuation here is important. But to get to the heart of your question, I don't think there's anything nonsensical or redundant about talking about using a random generator, number generator, to store numbers. I think it's not any different in principle with the phrase that a lot of people have used to describe the sense of the ATDS prohibition, which it prohibits dialing of numbers using a random or sequential number generator. In both contexts, I think the senses are very sensible. The sentences are very sensible. They just mean that you're using the number generator not to do the actual dialing or the actual storing, but as part of the process of storing telephone numbers to be called, or part of the process of dialing telephone numbers to be called. And I think if you understand the terms in that way, they make perfect sense in normal English. And I think what they really get at is the idea that Congress was trying to prohibit the use of a random or sequential number generator either for immediate dialing, which would be produce, or for later dialing, which would be captured even more aptly by the verb to store.
Justice Sotomayor?
Mr. Clement, with your parade of horribles that if read the way the other side wants, it would cover devices, too many devices. I'm wondering if the issue is less with respondents' interpretation and more so with the TCPA being outdated. When the Act was passed nearly 30 years ago, smartphones didn't even exist. Even today, it still references pagers, the TCPA. But you are right to note that today almost all phones have the ability to store and dial telephone numbers. If what Congress wanted to do was stop a call that was automatic, and that's what it accomplished, wouldn't it be its job, not ours, to update the TCPA to bring it in line with the times?
So, Justice Sotomayor, I definitely think that it's Congress's job to update the statute, but I don't think the problem with the other side's construction is something that only materializes with the modern smartphone. I think the basic problem also inhered in technology that was prevalent in 1991, like speed dialing or call forwarding, which involves the rudimentary capacities to store numbers and to dial them. And the FCC confronted that issue in the immediate wake of the statute's passage in a 1992 rulemaking. And it said, don't worry about speed dialing, don't worry about call forwarding. That's not covered because it doesn't use a random or sequential number generator. So I think there's for the entire history of the TCPA, there's been the potential for it to be read way too broadly. And I think since the very beginning, the sensible way to avoid that outcome is to read using a random or sequential number generator to modify both to store and to produce.
Thank you, counsel.
Justice Kagan?
Mr. Clement, I'd like to give you a hypothetical along the lines that Justice Alito was talking about. So here's the sentence. It is illegal to stab or shoot another person using a firearm. And what I want to know is, would I be covered if I stabbed somebody with a knife?
I think you would, Justice Kagan. You would obviously be covered if you stabbed somebody using a bayonet, I suppose. But I think that really gets to some of the sense that you provided in the Supreme Court decision in the Advocate Health case, which there are certain combinations of words where the mind just sort of rebels at the combination of the two words. And I think there it's very clear that you really don't, in the ordinary parlance, except for possibly with a bayonet, stab somebody using a firearm. But I don't think there's any comparable logical inconsistency or linguistic impossibility with using equipment to store telephone numbers to be called using a random or sequential number generator. And indeed, if you look at some of the state statutes that were passed before the TCPA, they all used a bunch of different formulations, but a number of them did address the combination of storage technology and a random or sequential number generator. And I think that feigned problem or an odd combination, particularly if you think about sequential number generation, where you generate thousands of numbers, you have to store them someplace. And it's really the fact that you're using the equipment to store the numbers and then dial them seriatim that creates the distinct risks to emergency lines and cellular phones and pager lines and the rest.
And quickly, Mr. Clement, could you comment on the surplusage problem that your reading creates?
So I don't think it creates a surplusage problem, Justice Kagan, and I do think the other side's reading creates a bigger surplusage problem. So on our side, I don't think there's a surplusage problem, because if I talked about using a power generator to store or produce electricity, I don't think you would read that as having the store to being completely redundant, because by using store or produce, I'd be making clear I don't really care whether you're using the electricity now or later. So I don't think it's purely redundant. On the other hand,
thank you.
Justice Gorsuch?
Good morning, Mr. Clement. You pressed what Judge Barrett, in her opinion for the Seventh Circuit, called the first potential reading. But the problem that it generates, as everybody's recognized, so to speak, is that it's awkward to speak of equipment storing anything using a random number generator. That's what Justice Alito and Justice Kagan have pointed out. One potential response to that might be that what Judge Barrett called the fourth potential reading, which is to say that the phrase using a random or sequential number generator modifies the object rather than the verbs. And it would be sensible to talk about storing telephone numbers that are to be called using a random number generator. The problem there, of course, is the comma. I see all that, all right? My question for you is you didn't raise the fourth argument as a potential. I'm not sure we need to rule it out. Would it make any difference to you and your clients and in any sensible way make a difference in the real world, whether we were adopting the first alternative or saying that the fourth might be a possibility too?
So, Justice Gorsuch, I think we would prevail equally under the fourth alternative, and as I'm standing here today, I can't think of a practical difference between the two. Obviously, when we're formulating our arguments, it's hard for us to ignore the comma, which is part of the reason we didn't press the fourth construction. The other reason we didn't press it, to be candid, is if you don't think there's anything terribly anomalous about talking about calling using a random or sequential number generator, then I don't know why you think there's something so anomalous about storing numbers using a random or sequential number generator. I think in both contexts, it's not the generator itself that does the calling or the storing, but in both cases, the number generator is used as part of the storage process or part of the calling process.
Very helpful. Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Clement. I want to touch on what you talked about, what Congress was getting at in 1991, and just make sure I understand the structure of the statute. Your point about calls to the home, only artificial or pre-recorded calls to the home were prohibited. Why didn't Congress also prohibit live calls, live telemarketing calls to the home, do you think?
Well, I think it's pretty clear from both the legislative history and the legislative findings that were enacted in the statute itself that the reason they didn't go after live voice calls to the home was out of respect for the First Amendment.
Okay, and then when you get to the other category of calls we're talking about, to the specialized numbers, Congress again prohibits the artificial or pre-recorded voice calls, but then also prohibits calls, which would presumably be live caller calls, using an ATDS. What was, in your view, Congress getting at with those calls? Am I right in thinking those are live caller calls that would necessarily be covered by the ATDS prohibition?
Well, they could, I think, be live caller calls. There's actually some debate about that, and I think if you look at the whole legislative history, there's a little bit of ambivalence about that. But let's say they call voice calls. I think the reason that they targeted those specialized lines, and as to those specialized lines, prohibited the ATDS in addition to the artificial or pre-recorded voice calls when they didn't do the same to the residential landlines is precisely because those were the lines that were particularly vulnerable to random or sequential number generation technology.
Right.
If you
The
dial numbers sequentially,
artificial or pre-recorded calls to those lines would have been already prohibited, though. So the ATDS must be getting, and I don't know which way this cuts, I'm just trying to understand it, would have been using that, an ATDS for a live caller call would have been the only thing separately covered.
Yeah, I'm not positive that's the way the statute is structured, Your Honor, because I think the prohibition to the residential lines only covers artificial or pre-recorded voice calls. And then as to the cellular and business lines and emergency lines, both are prohibited.
Thank you, counsel.
So they specifically singled out the cellular and mobile lines and the emergency lines, and they said as to those, we don't want either artificial or pre-recorded voice calls, or
thank you, counsel.
We don't want these ATDS calls.
Justice Barrett?
Mr. Clement, some of the lower courts that have adopted your opponent's interpretation have been moved by the exception in B, which says that liability doesn't attach if the call is made for emergency purposes or with the prior express consent of the called party. And, they've pointed out that under your interpretation, they say, listen, the prior express consent would do no work for an ATDS. I'm looking at the emergency purposes exception to liability, and I'm wondering how either an ATDS or an automated or artificial pre-recorded voice device would make a call for emergency purposes.
So, Justice Barrett, I think you could imagine either one of them making a call if there were a medical emergency, if there were an individual at large in the community. You could imagine a police department using this kind of technology to provide a warning message, and it could be a pre-recorded warning message to everybody in the jurisdiction.
So you think it would have some utility? I mean, I guess what I'm getting at here is I'm wondering whether, in an abundance of caution, you can imagine why Congress wouldn't want any call that was placed for emergency purposes or a call that was placed with express consent to give rise to liability. However, I mean, it may not be that there's very wide applicability for either one of those exceptions, including the one for emergency services, which I think would deprive the objection of some of its force that your interpretation renders the prior consent of not great utility.
I think it's going to be a narrow band of calls, but I do think they're calls that conceivably could be made with an ATDS, so I think the exception has some force. I do think, though, if you read the statute as a whole, it's pretty clear that the exceptions are mostly in there for the pre-recorded or artificial voice calls, because there's no exception in B1D, which is the one provision that applies only to ATDS calls.
Thank you, counsel.
A minute to wrap up. Mr. Clement?
Thank you. There are two final defects with respondents' view I'd like to emphasize. Under our reading, both disjunctive verbs are modified, and so both capture specialized conduct of comparable scope. Under respondents' reading, by contrast, to store is unmodified and captures a wide swath of conduct, while to produce using a random or sequential number generator captures only a narrow band of specialized conduct. That is not how Congress generally writes statutes. It does not put an elephant hole next to a mouse hole, prohibiting both everything under the sun and a highly specialized practice. And that points to the second problem. If Congress really wanted to prohibit every annoying call made with a device that can store and dial numbers, it would not have left the home front unprotected. In 1991, there were only about 7 million cell phones. The default telephone for almost every constituent represented in Congress was a residential landline. If the ATDS provisions were addressed to something broader than random or sequential dialing, Congress's decision to leave the residential landlines unprotected would be inexplicable.
Thank you, counsel. Mr. Ellis?
Mr. Chief Justice, and may it please the Court. In the government's view, this case can and should begin and end with the statutory text. Under ordinary rules of grammar and canons of construction, the phrase using a random or sequential number generator in Section 227A1A is best read to modify both store and produce. Now, respondent asks this Court to discard those rules and rely instead on the anti-grammatical sense of the passage, but he cannot show the sort of contextual implausibility of a grammatical reading that might warrant that approach. He also places significant weight on the purported consequences of the government's reading on the modern telemarketing industry. But that argument misconceives the limited role that the ATDS definition plays in the statutory scheme, both today and more importantly from the perspective of the 1991 Congress. Regardless of how the court resolves this case, the TCPA will continue to broadly prohibit robocalls to cell phones and residential lines. The fact that the 1991 ATDS definition describes a universe of devices that are no longer in widespread use provides no basis for this court to adopt anything other than the most natural reading of the statutory text. I welcome the court's question.
Mr. Ellis, you began by saying this case can begin and end with the statutory text. Are you saying it's a plain meaning case?
We think, Your Honor, that the interpretation we've offered here is by far the most natural reading of the text. Just like a case, in the other case where there's not an agency action at issue, we haven't gone so far as to weigh in on whether we think that a contrary approach by the FCC would be permissible. But I don't want to suggest suggest any lack of confidence in our reading. We do think it's by far the more natural one.
Well, I guess if you're saying it begins and ends with the text, that doesn't leave much room for the FCC to adopt a different interpretation from the one you're advancing.
I think that's right, Your Honor. I don't think there's much room for a contrary interpretation. Again, this is a question on which the FCC has requested comment twice since the D.C. Circuit's decision in ACA International. It's a question that's open on its docket. We are reticent to foreclose any contrary interpretation from the FCC without seeing what they had to say. But I agree with you completely that there's not a lot of room for a contrary interpretation here.
But that was a question, not a statement. What do you take? How do you react to the notion that this is going to have disastrous consequences, given technology that has developed since Congress passed this, and whether or not those consequences should enter into our consideration?
I think a couple things about that, Your Honor. I agree with my friend from Facebook that that shouldn't drive the court's analysis here. I think the question is what the statute meant in 1991. I also think that it sort of misconceives, as I suggested, the narrow role that the ATDS definition plays in the statutory scheme. The ATDS definition only implicates the automated call restriction to these sensitive lines, emergency lines, guest and patient rooms at healthcare facilities, and cell phones.
Thank you, Mr. Ellis. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Ellis, Justice Sotomayor brought up the point of the ill fit between the statute from 1991 and current technology, which is advanced in 91 cell phones. Quite a few of them were the size of a loaf of bread, and they're not in widespread use. Lots of people had car phones instead installed in their cars. We've had in legislation quite a change. The industry's changed. The technology is far beyond anything we could have conceived of in 91. At what point do we simply say, and I understand that the statutory construction and the what we're attempting to do with this statute, but at what point do we say this statute is an ill fit for current technology?
So I think in one respect, that may be true. I think the best reading of the ATDS definition as suggested doesn't apply to a great deal of technology that's still in use today. I think that's actually evidence of the TCPA's success and not a reason to update the statute. And on the flip side, as you suggest, the respondent's reading of the text does at least present a potential that ordinary smartphones could be, or calls from ordinary smartphones could be made unlawful. I think happily the best reading of the text doesn't lead to that result, and that's what we're urging for the court to adopt here.
But I think the point, what I'm asking is sometimes we use, I think it's a little odd when we use these, we make great effort to interpret a statute that really wasn't intended for the universe in which we are operating now. And at what point do we just simply say that?
I think you can say that in an opinion. I think that the court's approach shouldn't change based on that. I think the right approach for the court is to still engage with the statutory text as it's written, and if it needs to be updated, to leave that updating to Congress.
Thank you.
Justice Breyer?
No, I won't. Thank you very much.
Justice Alito?
I have two questions. The first is the one that I asked Mr. Clement. Does it make any sense to talk about a system that uses a random or sequential number generator in the very process of storing telephone numbers? The second is this. In order for your interpretation to be right, don't you have to show that there are or were systems that stored numbers using such a generator but didn't use the generator to produce the numbers? If otherwise, there wouldn't be any point in separately covering storage. So if you could cover those two perhaps in reverse order, I would appreciate it.
Sure. So I'll start with the latter first. I do think that this statute can be read to cover for both verbs to do independent work. But let me start by saying that I don't think that's a requirement for the court to adopt our reading. I think that the court has recognized in cases like Rimini Street and Atlantic Richfield that sometimes Congress does adopt a belt and suspenders approach. And so at most, I think respondent has shown that that's what they've done here. And I think that's the kind of superfluity that this court would lead the court to ordinarily to disregard the other ordinary rules of grammar or the other canons of construction. That said, I think, as my friend acknowledged, I think there are two types of ways that autodialers use random and sequential number generators, and I think it's natural for Congress to describe them both. And in fact, I think if you think about produce in the statute and what it likely means, I think it probably doesn't mean create, as respondents suggest, because autodialers or ATDSs won't be any use if what they do is create brand new 10-digit numbers that never existed before. They have to identify numbers that existed in the real world and have been assigned to telephone numbers. And so
they produce a list of numbers. What's strange about that idea?
I'm not saying that it's strange to think of a random and sequential number generator as creating 10-digit numbers. I think it's an awkward fit to say it's producing telephone numbers to be called if what you mean is create. I think rather what it probably means is bring forth or offer up. And so if that's the meaning that you ascribe to produce, then it's not inevitable that every use of a random or sequential number generator will produce numbers.
Thank you.
Justice Sotomayor?
Counsel, could I from the beginning have wondered, could a TCPA lawsuit against individual smartphone users actually prevail, given that smartphones don't automatically dial phone numbers in the way that a sequential numbering system does? It doesn't seem like a smartphone could be an automatic telephone dialing system. Am I missing something? Why wasn't that the main reason for reading things against the respondent? Reading this law is not applying to the respondent.
So as to whether the TCPA, the ATS definition, could include smartphones, as you suggest, if you read the second prong of the statute to include an automatic requirement, then I think that at least limits the circumstances in which an ordinary smartphone could be considered to be an ATDS. There's, of course, the second prong of the statute doesn't include the word automatic, and I think it's an open question as to whether that's the right way to read the statute. Courts of appeals on both sides of the split have assumed that, and the FCC has previously done it, but again, I think it's not actually there in the text. And that's, I think, if you don't adopt that reading, then it is when it begins to present serious problems for ordinary smartphones.
All right. Thank you, counsel.
Justice Kagan?
Mr. Ellis, at the time the TCPA was enacted, there were a fair number of state statutes that dealt with the same general subject matter area, and every single one of those statutes defined an autodialer to encompass at least some machines that didn't use a random or sequential number generator. So doesn't that suggest that your definition is wrong? I mean, would Congress really have wanted to depart from all of those state statutes in this particular way?
So I don't think it suggests our reading is wrong. I think what it suggests is that Congress approached the same problem in a different way. And so it's true that all or almost all the state statutes included devices beyond those that use random or sequential number generators. But it's also true that almost every state, I think all but two, only addressed devices that delivered a pre-recorded voice and then regulated those devices. Congress came at that same problem in a different way by first prohibiting all pre-recorded voice calls to residential lines and to the sensitive lines, regardless of the dialing technology, and then separately prohibiting a subset of calls made with an ATDS using a random or sequential number generator. At the end of the day, it's a similar approach. Indeed, Congress's approach is somewhat broader. It's just a different approach.
And why is it that Congress would have adopted that approach? I mean, if I understand what you're saying that Congress decided to cover these predictive dialers when there was an automated or pre-recorded voice, but not when there was a live person on the line. What sense would that have made? What difference does it make from the recipient of the call's perspective?
So perhaps I was unclear. Congress regulates pre-recorded voices without regard to whether they were delivered with an automated system at all. And they do that because I
understand that. But within that, they were definitely they definitely covered these predictive dialers. Isn't that right?
No, actually, predictive dialers, at least in 1991, as I understand them, typically didn't deliver a pre-recorded voice. They connected to a live operator. So I don't think the pre-recorded voice part of the statute covers predictive dialers.
There weren't any of these that existed that were predictive dialers with a pre-recorded voice?
There may have been. My point is that in the whole, predictive dialers, the way they work, the whole point of them is to sort of time up the call so that there was a live operator available when the call was connected. They were principally ways to connect live operators. And I'm sorry.
Justice Gorsuch?
Good morning, Mr. Ellis. Two questions. Take them in whatever order you care. First, I think your argument depends upon the possibility that in the world time Congress adopted the statute, there were devices that used random number generators to store telephone numbers. So what evidence do you have that this existed in the world, number one? Number two, the same question I posed Mr. Clement with respect to what Judge Barrett, in her excellent opinion, called the fourth possible interpretation. I understand the problems with it, but it does overcome this difficulty. And it wasn't addressed in the briefs, and I'm just curious why it wasn't addressed, and whether we need to rule it out, or whether it would make any difference going with the first versus the fourth.
So as to your first question, whether there were devices in the world that stored using a random sequential number generator, I would point you to the page 19 and 20 of our brief, and then the Pace and Noble Systems amicus brief that goes through this in some detail, that describes that automatic dialing systems in 1991 either use a random sequential number generator to generate numbers and then immediately dial them, or use them to generate numbers, store them for subsequent dialing. And I don't think it's unnatural to describe the latter system as using the random or sequential number generator to store the numbers in the same way as that you might say that I have a backup power generator at my home that both generates and stores power for subsequent access, or in the way you might say you might describe using a web browser to download and store a file, that is to say doing something more than just browsing the web. As to the second question about why we haven't addressed, I actually do think we did address that. That possible interpretation, we think it is not available because of the comma.
No, I understand that. That's not my question.
Okay. As to the practical consequences of that, I think you should not leave it open. I think it's not the best reading.
I understand that, too. That wasn't my question either.
Okay. I'm sorry.
My question is, does it make any difference in the real world?
Yes, it does. And the difference it would make in the real world, at least if I think you would understand calling using a random sequential number generator, that could describe taking a set list, a sort of pre-selected list, and then calling them in random order. But that's not the problem that Congress was trying to get at with the ATTS definition. The problem was getting at with that definition and the restriction was calling indiscriminately, calling unintentional numbers. That would result in telemarketers accidentally calling emergency lines and cell phones and guest and patient rooms. That was what Congress was trying to get at with the prohibition.
Justice Kavanaugh?
Thank you, and good morning, Mr. Ellis. Justice Thomas and Justice Sotomayor, I think, and others have talked about the ill fit of the statutory language to current technology, and I want to break that down with you a bit, because there are two, as you've indicated, two prohibitions here. One is the prohibition on artificial or pre-recorded voice calls, and that covers artificial or pre-recorded voice calls to the House or to these specialized lines. Correct. And that part of the statute still makes sense and applies today, correct?
Correct.
Okay. So then you have the ATDS prohibition, which only applies to the calls to specialized lines, does not apply to calls to the House. And because artificial and pre-recorded calls are already prohibited, must be getting at something different than artificial and pre-recorded calls. And I'm trying to figure out, one, what's that getting at the time? What was the real world problem? And two, does that have any relevance at all today, as Justice Thomas and Justice Sotomayor were indicating with the ATDS prohibition?
So I think what it was getting at, Your Honor, was one, it may have also been sort of a belt and suspenders in addressing those pre-recorded calls. But I think
can I stop you right there? Do you think, and this gets to Justice Kagan's question, what Congress was drawing on, do you think they meant and instead of or and made a mistake?
No, I guess I don't think that. I think what I was going to say is I think live operated calls to those sensitive lines could equally cause problems. I don't think we want telemarketers calling 911 lines or bothering people in their patient rooms at healthcare facilities, or in 1991 making calls to cell phones, which were unintentional at the time and would then cost the called party by the minute. I think those sorts of problems, they're exacerbated by pre-recorded voice calls, but they're caused also by indiscriminate calls that connect to live operators.
Justice Barrett?
So, Mr. Ellis, some of the lower courts have characterized this provision as ambiguous and, said that leaves the FCC some room to choose whether this applies, to this kind of stored situation or not. And you, in your colloquy with the Chief Justice, suggested that although the FCC, may have a narrow band of authority, you weren't ruling that out either. And I guess I'm wondering if you could explain why you think any kind of Chevron deference would apply here, where we have two conflicting choices and we have to decide which is the best one. Because I would have thought that Chevron, that the premise of it is that when Congress deliberately chooses open-ended language or vague language, it's implicitly delegated to the agency a range of discretion to make the choice. But this kind of thorny statutory provision doesn't strike me as reflecting an implicit congressional choice to delegate to the FCC how to regulate this.
So I think that's a fair question, Your Honor, and I would just say that I think the court has often, in the Chevron analysis, asked, is the statute ambiguous, and then took that ambiguity as an indication of Congress's delegation. We haven't addressed those issues here for the obvious reason that there isn't an outstanding agency interpretation for the court to gauge whether it should get Chevron deference or not. But I think it's a fair question.
Thank you, counsel.
A minute to wrap up, Mr. Ellis.
Thank you, Mr. Chief Justice. I think I'll close with just one more word about the surplusage problem that the respondent purports to have identified. For the reasons I explained, I don't think the government's reading presents any meaningful surplusage. But even if you disagree, I think at most what respondent has shown is that Congress took a sort of belt and suspenders approach here. He certainly hasn't shown the sort of superfluity that would warrant discarding the ordinary rules of grammar and other canons of construction. And I think that's particularly so in light of the superfluity that respondent's own reading would introduce. He makes clear on page 37 of his brief that in his view, Congress drafted the ATDS definition to encompass, quote, all technologies used to deluge cell phones with automated calls. But if that were so, it's not clear why Congress would have included the first prong of the definition at all. Under respondent's reading of the statute, you could strike not just one word, but the entire modifying phrase using a random or sequential number generator, if not all of Section 227A1A, and the ATDS definition would reach the exact same universe of devices. That's the sort of superfluity that the court ordinarily will not countenance, and we urge the court not to do so here. Thank you.
Thank you, counsel. Mr. Garner?
Mr. Chief Justice, and may it please the court, any method of interpretation, textualism, purposivism, consequentialism, favors affirmance here. Congressional purpose is overwhelmingly clear. It's privacy. Let me focus, though, on text. The issue here involves ordinary lexical meaning, grammar, and cognition. An example, to maintain or acquire lands to be developed using eminent domain. No linguistic rule should lead us to conclude that we must maintain lands using eminent domain. The adverbial modifier links up with the verb acquire. That's ordinary meaning. Other canons are crucial. First, the conjunctive-disjunctive canon. The word or denotes two distinct categories, storing and producing, and the word order is significant. Second, the surplusage canon. The words store and or are given real work to do only on our reading. Third, the harmonious reading canon. The consent provision in this statute makes little sense with random number generation. You obtain consent from known people. Fourth, the presumption against ineffectiveness. Facebook would read the statute into oblivion because robocallers today use stored phone numbers to annoy people, just as they often did in 1991. In Barr, just 5 months and 2 days ago, this court repeatedly said that the act prohibits almost all unsolicited robocalls. The borrower's numbers in that case would have been stored. The court, having invalidated the exception in that case, Facebook now argues for an across-the-board exemption. Effectively, all autodialer calls and messages are exempt, they say. In reading law, this is called a viperine interpretation. Like a viper, it kills the statute and privacy.
Thank you, Mr. Garner. You agree, don't you, that our objective is to settle upon the most natural meaning of the statutory language to an ordinary speaker of English, right?
Yes, Your Honor.
So if these various rules of construction, viperine or something else, those are only pertinent. We don't assume that the ordinary speaker is applying those canons or rules of syntax at all, right?
Your Honor, that's correct. Most native speakers of English, competent users of the language, understand. For example, cookbooks are full of statements that say, using a spatula, lift the omelet and tilt the pan. Nobody stops to parse it and say, oh, do I have to use the spatula to lift the pan?
So the most probably useful way of settling all these questions would be to take a poll of 100 ordinary speakers of English and ask them what it means, right? That would be the most useful rule of construction.
I'm not sure that we would just take a poll of everybody and say, I think it would be a useful datum, yes.
Okay, sort of shifting a little bit here, you say that if Facebook wins, we'll all be flooded with robocalls. Well, doesn't the statute independently bar calls with artificial or pre-recorded voices, which I think is what most ordinary speakers of English would regard as a robocall?
Your Honor, the difficulty with having ordinary speakers or readers try to read a legislative definition like this is immediately people would be a little bit befuddled by the legal language. They just would.
Well, lawyers too, I guess. But the point is that Congress didn't write the legislation with the technical rules in mind, and I think ordinary speakers wouldn't read them that way. And so the most useful tool is kind of your first blush reading it in terms of how it makes sense. And I think most people's first blush would suggest that the friend on the other side's reading makes the most sense.
Your Honor, I respectfully disagree if you take into account the actual meaning of the words. But if you just looked at it sort of mechanically and hastily, yes, it's possible that that is the way it would strike people. As Justice Holmes once said, a well-drafted statute, this is paraphrasing slightly, a well-drafted statute must be able to withstand attacks by an intellect fired with a desire to skew the meaning, and I think that's a problem.
What significance does it make that the ordinary speaker of English we've been talking about would have a very different knowledge background about these things today than one would have in 1991?
Your Honor, I believe that TCPA is more important today than ever because of advances in technology. The social media companies know exactly where you are at all times. They know every mouse click that you've made for the last 20 years, and they can target in a very manipulative way. So the basic technology of getting a message through to somebody who's carrying a handheld device remains the same.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Garner, taking off your last point, the technology has changed. I think we're talking about the average person. Most people would have no idea today what some of the technology was. In 1991, a pager, most people would not realize that caller IDs were cutting edge and had to be purchased separately, that most people did not have cell phones. In fact, very few people did, and they were large, and car phones had to be installed. So technology has changed and moved along very rapidly. And don't you think it's rather odd that we are applying a statute that's almost anachronistic, if not vestigial, and to modern technology like Facebook and instant messaging, et cetera? Don't you think that at some point there's at least a sense of futility?
Your Honor, I don't. The average American is very well familiar with robocalls and understands that these numbers actually doesn't care whether they were randomly generated or whether they were sold because they gave their number to somebody, and in fact would probably be more offended if they understood that somebody that they had dealt with and trusted had sold their numbers.
But you make my point, because it doesn't have to be randomly generated anymore. It's generated in other ways, but you make my point about technology. In the old days, it would be randomly generated because there was no way anyone could have that much information and use it that instantaneously.
Your Honor, in 1991, there were lots of stored numbers that were called. In fact, I hesitate to talk about legislative history because I don't like talking about legislative history, but lists and databases of known numbers came up over 200 times. Generators came up only 4 times in the whole legislative history.
Thank you.
Justice Breyer?
Interesting. Garner, let's go back to when they wrote it. As you read it is unlawful to call a hospital, for example, using a phone that stores telephone numbers. Period. Right? Is that right or not?
That's not quite right, Your Honor. It's illegal for the equipment to call. It has to be an automated dialing system, not just, just a cell phone.
You can't have equipment. Where's the automated? Where did you say that? Let's see. Using an automatic system, I guess. Okay.
Yes.
So you can't use an automatic system that stores numbers. Now, then, were there a lot?
Your Honor, there were databases.
Were there a lot, or did they? What was the situation like then?
Your Honor, there were databases and lists that were sold, and there were also numbers automatically generated, but those are shots in the dark. That's why those have become superseded. Facebook's interpretation.
Yeah, okay, I got it. So there, at the time, there were systems that stored numbers both ways, and that's why you think they wanted to get it both ways.
Yes, Your Honor.
And then over time, what happens is the world changes, so everybody and his uncle has a system that fits within that ordinary definition. On cell phones, storing, then automatically dialing. Yeah, we all have one. And so it gets too broad, and so you narrow it. Now that seems like the converse of a situation where, the famous, all these examples, the silver fox is not thought to be an endangered animal, an endangered species when they wrote that. But later it is, so you say, was there a dynamic meaning, which changes over time to pick things up, or is there static meaning? Just look back and see what they intended at the time. And Nino Scalia always used to say, oh, that's just done to expand the statute. But here, we're using it to contract the statute. Any comment? Is that totally wrong? I suddenly began to think about it that way.
Reading it to be just random number generators, which produce numbers, to that specific technology would wither the entire statute. That's why I call it
contract. It would contract. You say wither, that's pejorative. But so often we interpret a statute dynamically to adapt to changing circumstances, looking at the context in which it is passed and how it's changed, in order to decide how to do so. And to do so here, there are a few words over there that really help. Is there anything wrong with reading a statute? Looking for the intent in terms of change over time. Did Congress intend it to change over time as technology changed, and then using the tools at hand in the context at hand to produce a more sensible interpretation? What do you think?
Your Honor, I'd have no quarrel with any justice who wanted to do that, even though
I'm asking you in your expert view. What do you actually think about such a thing? I haven't really seen it. It just doesn't occur to me that this fits in that box, possibly.
I'm a proponent of the fixed meaning canon, but I do think that the word store and or, it makes Congress look almost prescient. Given what has happened in the last 29 years, Congress looks prescient, having said store and or before produce.
All right, I'll think about it. Thank you.
Justice Alito?
Guido Calabresi has argued that courts should have the power to declare statutes obsolescent and obsolete. And if we had that power, this statute might be a good candidate, but we haven't claimed it so far. And assuming we don't, perhaps we have to put out of our minds the whole parade of horribles that arises as a result of the advent of smartphones and social media. So if we think about the technology that existed at the time when this statute was enacted, the bit of technology that seems to me to provide the greatest practical problem for your interpretation is call forwarding, which I think was widely available when this statute was enacted. So would any machine that had a call forwarding capacity at that time be covered under your interpretation?
Your Honor, no, nor would an immediate answer. In fact, a normal cell phone and normal uses of cell phones do not amount to an ATDS. It would have to be altered significantly to become an auto dialer. But human intervention is the thing that makes it something that is not automatic. Anything that needs a push of a button to send a message. Automatic dialing has been pre-programmed to send messages automatically at intervals without human involvement.
Well, isn't it true that at least as of now, everything that computers do requires at some point some degree of human intervention, some degree of human instruction?
That is true, Your Honor, but that involves not uploading a list of numbers. That involves human involvement, but it's the selecting of the number to be called and when to call. That is the human intervention, the immediate placing of the call that the FCC, the ACA, and the D.C. Circuit and the 11th Circuit have all held that human intervention does exclude those calls from definitions of ATDS.
And how would you define the degree of human intervention that's required?
Your Honor, it could be pressing buttons. It could be clicking a mouse on a number. It involves a human being sending a message or placing a call, and it's the direct placement of the call.
Thank you.
Justice Sotomayor?
Counsel, if we rule your way, the logical consequence is that every cell phone owner would be subject to the harsh criminal and civil penalties of the CPA. Could you give me a reason, other than that it hasn't happened yet, for for why Congress would have intended that. And by the way, it seems, please don't answer by saying it hasn't happened yet. And the reason I say that is because if you get a ruling in your favor, I know for sure that there will be lawsuits against individuals that will follow.
And, Your Honor, I believe Article 3 judges know how to deal with those, what I imagine to be frivolous claims. But Facebook's scary argument that all cell phones might, with alterations, be made into automatic dialers really should be no more availing than the realization that all of us have hundreds of deadly weapons in our homes. Law-abiding Americans just don't use rope and kitchen knives that way.
I think you're going to have to answer me more clearly than that. You don't think that cell phone users will do what? So
they won't do automated mass dialing or blitz messaging, which isn't a normal function on a cell phone.
Well, I mean, I do email blasts with friends. I do all sorts of, now with FaceTime and things of that nature, Zoom, we're doing basically automatic dialing and people being joined together by that process. So I, for one, don't believe that we should think that our interpretation couldn't affect the development of new technology to help people do things more quickly. But in the process, end up violating the statute.
Your Honor, it seems to me that this court, like the D.C. Circuit, could actually disclaim the result that normal uses of cell phones would produce liability. But there is a question of functional equivalence, and the prohibition speaks of consent. The difference between text messaging groups and friends is that everybody has consented. There's not a problem. The difficulty is when people's privacy is being invaded. That's what the statute was driving at.
Counsel.
Justice Kagan?
Mr. Garner, you started off by noting that there are some kinds of statutes or sentences where the meaning of the words is so clear that the mind gravitates toward the ungrammatical reading. And that might well be, but would you at least acknowledge that the reading that you are asking us to adopt is in fact ungrammatical? That you have two verbs, store and produce. They have a shared direct object, numbers to be called, and then a modifier following all of that. So sort of setting aside the semantic arguments for the moment, do you agree that the grammar favors Facebook?
No, Your Honor, I don't think there's anything ungrammatical about this sentence. It's an unusual sentence, unusual syntax. It rather shows the infinite variety of the kinds of sentences that English speakers can devise. But just as in using a spatula, lift the omelet and tilt the pan, there's nothing ungrammatical about that. There's no rule of grammar that any grammarian has recognized that would render this ungrammatical. Perhaps a little awkward, but not ungrammatical.
Well, I think you just made the statute into something that's not. I mean, you took out the shared direct object. You took out the fact that the placement of using a random number generator phrase is after both verbs. So you considerably cleaned it up, I would say.
Your Honor, maybe my better example is to maintain or acquire lands to be developed using eminent domain. That may be the better.
That's one where I take the point that it's just like sometimes grammar has to give way because the meaning is so clear. And there the meaning is so clear because you can't imagine eminent domain being used to maintain land. It's kind of like, that's impossible. And so, too, for your argument in your brief about, what does it mean for domestic airline to drive? But I think that the point that Mr. Clement might make here is that the meaning here is not so impossible. There's a little bit of awkwardness about saying that a number generator stores numbers, but actually that can be explained by looking at the kinds of dialing devices that existed at the time, where there were devices that generated numbers for immediate dialing and devices that stored numbers for later dialing. So if that meaning is possible, shouldn't we go with that meaning when combined with the fact that it's the most grammatically proper way to read the sentence?
Your Honor, again, I would not concede that it's more grammatically proper way of reading the sentence. To me, if you look at the sentence, it seems clear and deducible from the text itself that Congress was concerned about known numbers, previously known numbers obtained from any source. Those are stored, and numbers not previously known but generated by one of these machines. That covers the universe of numbers, and the wording therefore makes sense. Another little thing I might mention linguistically is that some verbs, lexical verbs they're called, feel complete on their own, and store is one of those. We all know what computer storage is. But a word like produce, if you say, and produce the numbers, that you think, what does that mean? It's sort of like a sentence, the bird chirps and lies. We know what the bird chirps means, but lies, what do you mean lies? Well, the bird chirps and lies comfortably in its nest. Now, we wouldn't think that comfortably modifies chirps. And it's that kind of need to have the adverbial modifier explain to us what we mean by produce. Computer production could be the manufacture of computers. It just doesn't feel complete. I think that's the reason
for the... Thank you, Mr. Garner.
Yes.
Justice Gorsuch.
Good morning, Mr. Garner.
Good morning.
You conceded that the grammar here is awkward, but I'd like to pick up where Justice Kagan left off, and I think you certainly have an argument that grammar doesn't exhaust meaning. Fine. But on what basis is this sentence grammatical? I think it's so awkward I'd anticipate you'd rewrite it if it were given to you. When we look at the adverbial phrase, there's nothing to indicate in the statute that it modifies only one of the verbs. And rules of grammar usually indicate that when you have a clause like that offset by a comma, it would modify both of the prior verbs, right?
No, Your Honor, that is a rule that you sometimes find as an exception to the rule of the last antecedent. That's about the only place. And you find that rule only in law books, not in grammars. It's unrecognized by grammars. But the point of synesis is simply that we must look at the semantic content of the words. We don't take the words as just fungible morphemes and say once you hit the comma, everything before it gets modified.
Well, let me ask you this. In response to Justice Alito, we're talking about what happens if we were to interpret the statute your way. And I guess I'm still a little unclear about the answer there. To store a number, if it's totally divorced from the random or sequential number generator, and then to dial such number would seem to be enough. Others have worried about our contemporary cell phones that can do that. But even at the time of the statute's adoption, there were phones that captured numbers that had been dialed, and you could press redial. Why wouldn't, and that was common even in the 1990s, I believe, certainly a lot earlier than cell phones. Why wouldn't this statute make a criminal of us all?
Your Honor, each of those actions that you described involves human actuation.
I understand it requires a human person to push the redial button, but in what way does the statute require that on your reading?
Just to make sense of the provision.
Well, all the statute says is you have to have equipment that stores a number and can be used to dial the number. I don't see where it excludes human actuation as part of the equation.
Well, that's the word being defined, automatic dialing system, and it must be the equipment itself that does the dialing.
No, the equipment has to have the capacity to store, and it has to have the capacity to dial. It doesn't say it must do it solely by itself. I mean, now we're really changing the grammar, aren't we?
No, I don't mean to, Your Honor. That is in the definition, the capacity to store and dial.
So, and the capacity to dial. Nobody doubts that my redial button, my phone with a redial button, circa 1990, has a capacity to redial a stored number. Really?
Your Honor, it's not considered automatic when you place the call. If you press the button, that's what That's what
Congress can define anything to mean anything it wishes, right?
That's correct.
All right, so it can define an automatic dialing system to mean whatever it wishes, and here it defined it to mean equipment which has the capacity to dial a stored number on your interpretation.
Yes, and the equipment itself does the dialing.
Where does that come from, though? You're putting in a lot of words there.
I don't think so, Your Honor. I'm looking at the definition itself. The term ATDS means equipment that has the capacity to dial such numbers. It's the equipment that dials. And the word automatic is the word being defined. That's where the courts and the FCC have gotten the idea that human intervention is so critical to take it out of to take normal cell phone use out of the realm of ATDS.
I certainly understand that's necessary to avoid a parade of horribles. Thank you.
Justice Kavanaugh.
Thank you, Chief Justice, and good morning, Mr. Garner.
Morning.
This case will depend heavily, ultimately, on the text, and that's been well covered in the briefs and in other questions. I'm not going to belabor that in my time, but I want to ask some more questions to follow up on my prior ones, trying to understand how this worked in 1991 and how it works now and what it's getting at. So, first of all, even if we agree with the other side here, robocalls are still prohibited, meaning artificial or pre-recorded calls. That part is not affected, not involved in this case. That part of the statute's not obsolete at all, and that's part of the statute, even if you were to lose, will still operate to prohibit pre-recorded or artificial calls to the home or to cell phones unless an exception applies. Correct?
Your Honor, I don't believe that is correct. Robocalls is defined in the Trace Act from last year. Congress defined it to include all violations of this statute. That is, robocalls.
Assume I'm using it just to mean artificial or pre-recorded calls.
Yes.
If I use it that way, that part of the statute is not at issue in this case. That part of the statute will still apply even if you were to lose this case, correct?
Yes, Your Honor.
Okay. Then you said that the purpose, I think you started with this, the purpose of this separate ATDS prohibition, separate from the prohibition on artificial or pre-recorded calls, the purpose of this was privacy, at least in part, I think you suggested. Problem in fitting that...
The entire TCPA is about privacy.
Okay, but this provision in particular, and the problem with the structure of the statute that creates is that the ATDS prohibition does not apply to calls to the resident. And that suggests that the ATDS prohibition is about something other than privacy. How do you respond to that?
Your Honor, there were different protections given in different ways by Congress. The residents did prohibit those pre-recorded calls. And they also have a do not call list that they're protected by. In the case of cell phones and pagers and emergency numbers and so on, it was a do not call mandate across the board unless you have consent or it's an emergency. So there were reasons perhaps for this. One is that cell phones are carried on the person and they're therefore with you at all times. Like pagers, they receive text messages and residential lines don't. And people were having to pay for receiving calls, and some people still do, by the way, on some plans. But as one of the opinions in Barr said, in 1991, the cell phone owner not only suffered the pleasure of receiving robocalls, but also paid for the privilege.
Okay. As you referenced in the brief the state statutes, those, of course, prohibited at the time ATDS technology combined with pre-recorded or artificial messages. Congress severed those two things and separately prohibited pre-recorded or artificial messages and then separately ATDS, even with a live operator, presumably. Doesn't that suggest the state statutes aren't especially probative here?
Your Honor, I think they are worth looking at. For example, the placement of using an artificial, using a random or sequential number generator. But there was a great deal of variation among the states, and what we ended up with is a federal statute that is very nuanced and represents a great many legislative compromises.
Thank you very much.
Justice Barrett?
Mr. Garner, you've talked in response to a number of the questions that you've been asked about the need for human intervention. In response to Justice Gorsuch, you talked about the finger hitting the redial button or the finger hitting the stored number in the phone. What about using the auto reply function on an iPhone? So I can set that up to say, do not disturb me, I'm driving, or do not disturb me, I'm sleeping. And I can program the phone, and this just comes with the iPhone, it's not special software, to be sent to my favorites or to all my contacts. So is that the necessary human intervention? I'm not pressing the button each time.
Your Honor, it's not an auto dialer because the communication is prompted by...
That's not what I asked you.
person.
I asked about human intervention. Is that considered human intervention?
I think that is a different circumstance, Your Honor. We're actually programming it would not involve human intervention, but the consent provision takes it out of the prohibition.
Mr. Gardner, I didn't ask whether it was covered by the statute. I asked you whether that counts as human intervention. Because a lot of your argument leans on this idea that, well, human intervention means that we're pressing the buttons on the phone that automatically make the call. Justice Alito asked you, how far back does that go? Because obviously human intervention is present at some point. And many people, your opponents, several of the lower courts, the Seventh Circuit and Cadillac, have said that it seems like, on one reading of the text, the auto-reply function would be brought within the statute. And I'm not asking you for all of the arguments to that effect. I'm only asking you about the human intervention point. Would that be enough? One step removed by using the auto-reply function, does that count as human intervention?
Your Honor, I don't believe it is.
And why? How do you tell when human intervention is close enough to not be human intervention anymore or to be human intervention?
There are difficult cases and shades of gray, and I think the clean bright line test that Congress devised is consent. The idea that there are going to be a lot of cases about...
Okay, Mr. Gardner, let me just stop because I wasn't asking about the consent because I want to ask you about something else too. So you talked in your briefs about this concept of synesis. And I'm wondering whether you can identify any case, because your opponents say there is none, in which a court has relied on that concept. And I ask because it strikes me as the kind of concept that might make sense in some interpretive contexts when one interprets some kind of language, say literary language. You lean heavily on this idea that the ordinary speaker of language or what would make sense to people. And synesis kind of gets at that but gives it a different name. Is that a legal concept? I mean, you and Justice Scalia don't talk about it in reading law, but you do talk about it in modern English usage, which of course gets at a far broader range of interpretive problems and grammar problems. So is it a legal concept? Is it appropriately applied in the law?
Your Honor, it's a linguistic concept that has been often recognized in the law. In fact, this court has frequently said that we go by the sense of the words more than by some pedantic rules of grammar. The court said that through the decades many times.
And is that a proposition that you would endorse? It seems like going through the sense of the words and the purpose of the statute would be contrary to the mode of interpretation that you've endorsed in other contexts.
Your Honor, I don't endorse that broadly, as it commonly appears. It tends not to appear in the post-Scalia years, and I don't endorse it broadly. And yet, it does recognize that we must look at the sense of the words to understand the sentence.
Thank you, counsel.
Mr. Garner, you can take a few minutes to wrap up.
Thank you, Your Honor. I'll take 60 seconds. On Facebook's reading, it would have been possible, even in 1991, to download the entire phone book and auto-dial every number with impunity, thousands per minute, as long as you stored the numbers on a floppy disk or hard drive. Just don't store them on an algorithmic number generator, a piece of equipment not even meant for storage. The statute never sensibly meant that. This case isn't about cell phones calling. It's about cell phones being called. It's about computer systems that send out millions of illegal calls and messages per day. There's no reason to think that Congress thought haphazard non-consensual calls to be bad, but targeted non-consensual calls, far more intrusive, to be quite acceptable. In Barr, this court said that debt collectors aren't free to send in the robot. Now Facebook wants to free up all the robots for unsolicited calls. We urge the court to reject this misreading and affirm.
Thank you, Mr. Garner. Mr. Clement, rebuttal.
Thank you, Mr. Chief Justice. Just a few points in rebuttal. First, the point has been made that there's some awkwardness between talking about the verb store and using a random or sequential number generator. That awkwardness could only matter for one of two reasons. One, it could matter if it were just impossible to use a random or sequential number generator to store numbers. But it's not impossible. It's not technologically impossible, as the Pace and Noble brief makes clear, nor is it impossible as a matter of ordinary usage, because as long as I'm using the generator as part of the storage process, the word makes sense just like dialing using a random or sequential number generator. The other reason it could matter is because there's a superfluity problem, such that anything that uses a random number generator to store numbers will also use the generator to produce the numbers. But if we're talking about superfluity here, there's a far greater superfluity problem on the respondent side of the case, because they would essentially read the words using a random or sequential number generator out of the statute. And you can't read this statute, particularly when you understand the limited scope of the ATDS prohibitions, without thinking that that phrase is at the heart of the statute. Second, there's been some discussion about how automatic something needs to be and whether that could save the cell phones. There's 2 points to make about that, Your Honor. First of all, the adverb automatically, the adverbial phrase without human intervention, the adverbial phrase en masse, none of those phrases is in the statute. And what is in the statute and the modifier that actually gives an automatic telephone dialing system a sense of automaticness is using a random or sequential number generator. But even if you read that word into the statute, it doesn't solve the problem. If I tell Siri to dial a number from one of my stored contacts, that's about as automatic as dialing gets. And call forwarding, even back in 1991, was just as automatic. You'd call somebody's number thinking you were getting one line, and it would automatically forward you to a different line. And of course, if you typed in the wrong line to forward it to, you could be looking at a lot of liability under the under the TCPA. Finally, a lot of discussion about the importance of 1991 versus 2020. Obviously, 1991 is what's most important for interpreting the statute itself. And if you look at that, things even that existed in 1991, like call forwarding, the problem was raised, and the response from the FCC was, no, look at the statute. Those aren't covered because they don't use a random or sequential number generator. If you look at the testimony before Congress in 1991, it's telling. The Direct Marketing Association didn't oppose the automatic telephone dialing system prohibition because that's not what they were doing, even though they were using stored lists. The person who opposed it was a guy named Ray Coker, who made these automatic dialing systems that used a random or sequential numbering device. And lastly, just let me say that 2020 may be relevant, particularly for constitutional avoidance. So for all those reasons, Your Honor, we ask that you reverse the Ninth Circuit.
Thank you, counsel. The case is submitted.
We will hear argument next in case 19-963, Henry Schein versus Archer and White Sales. Mr. Shanmugam?
Thank you, Mr. Chief Justice, and may it please the Court. This case presents an important question concerning the interpretation of agreements that delegate questions of arbitrability to the arbitrator. In its decision on remand, the Court of Appeals recognized that the arbitration agreements here contained a valid delegation. But it held that because the agreements also contained a carve-out provision, they divided up responsibility for arbitrability between the arbitrator and the court. The Court of Appeals proceeded to decide the arbitrability question for itself, thus effectively negating the delegation altogether. That reasoning cannot possibly be correct, and respondent does not seriously defend it. This Court should once again vacate the Court of Appeals judgment. To do so, the Court need only apply two settled principles. First, a delegation is simply an antecedent agreement that is subject to the rules governing arbitration agreements more generally. Second, any doubts concerning the scope of arbitration agreements are resolved in favor of arbitration. And under that presumption, a carve-out provision that does not speak to who should decide questions of arbitrability cannot restrict the party's delegation of those questions to the arbitrator. Respondent primarily focuses not on the question presented, but on another question, whether the incorporation of arbitration rules that authorize the arbitrator to resolve questions of arbitrability constitutes a valid delegation. But the Court correctly declined to add that question at the certiorari stage because 12 circuits have held, without conflict, that the incorporation of arbitration rules is sufficient. That holding is plainly correct, and overturning those decisions without the benefit of full briefing on both sides would work an evulsive change in the law. The Court should stick to the question it agreed to decide, and it should decide that question in petitioner's favor. The judgment of the Court of Appeals should be vacated. I welcome the Court's question.
Thank you, counsel. When you look at the pertinent clause at issue here, the one thing that's clear is that they did not want action seeking injunctive relief to be arbitrated. They say that expressly right at the outset. As soon as they say any dispute, they have the carve-out right there. So they didn't want arbitrators dealing with actions seeking injunctive relief. Now, if that's the case, and it was important enough for them to spell it out right at the outset, wouldn't the last thing you'd think they would want is for an arbitrator to decide which disputes qualify? I mean, that would seem to follow a fortiori. They don't want arbitrators deciding this. Why would they want arbitrators to decide who gets to decide it?
Mr. Chief Justice, I agree with you that the carve-out provision plainly carves out actions seeking injunctive relief from the scope of the arbitration agreement. But the question we're talking about this morning is a different one. It's whether they intended to carve out disputes about who decides whether something falls within the carve-out.
No, that was my precise question. If they don't want arbitrators around injunctive actions, why would they want arbitrators to decide who gets to decide that?
Well, I think that that's because it is highly unlikely that parties would ever want to divide up responsibility for arbitrability. After all, the whole point of a delegation is to resolve the who decides question. It's to streamline the process by having the arbitrator decide the scope of the arbitration agreement. And I think that the Court of Appeals opinion in this case well illustrates the problem here, because the Court of Appeals, having said that the plain language of the agreement divided up responsibility for arbitrability, proceeded itself to resolve that very arbitrability question.
Well, but they divided up the universe of actions here between some that will be arbitrated and some that won't be. And I don't know why you'd have such a presumption against doing the same with respect to arbitrability.
Because arbitrability is different, Mr. Chief Justice. It's the question of who decides. And where you have a dispute, it would be very strange to say that the question of who decides is itself divided, because somebody would have to resolve that doubly antecedent question. And I would be content to argue that our reading is the better reading of the agreement as a matter of common sense. But our submission here is simple. It's that the presumption of arbitrability should apply, and the Court of Appeals erred by failing to apply it here as a matter of federal law.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Shanmugam, it sounds as though you think this is that the delegation of arbitrability is all or nothing. How would you draft this provision so that it can divide the ability to the authority to arbitrate?
Justice Thomas, we don't think it's all or nothing, though, again, we think it is highly unlikely that the parties would want to divide up responsibility. But suppose that you had a provision, much like the provision at page 27 of Respondent's brief, that said something along the lines of, except for an action seeking injunctive relief, the arbitrator shall decide whether the party's dispute is subject to arbitration. There, the carve-out clearly and unambiguously would operate on the question of arbitrability. But we'd still be left with the problem that I was just discussing with the Chief Justice. In that circumstance, someone would still have to decide whether the action is, in fact, an action seeking injunctive relief. Someone would have to decide where there is a dispute over whether the arbitrator or the court should decide arbitrability. And again, the Court of Appeals decision well illustrates the problem, because having held that the parties divided up responsibility, the Court of Appeals proceeded to decide the question of who decides for itself, and thus effectively negated the delegation altogether.
Could you just give me, help me with the delegation language in this contract, this arbitration agreement? Where is it? I don't see the word delegation at all, or a verb delegate at all. Would you walk me through that?
Sure. And Justice Thomas, this goes to the question that Respondent is seeking to insert into the case, but I'm happy to address the merits of it directly. The question is whether the incorporation of arbitration rules that authorize the arbitrator to resolve questions of arbitrability constitutes a valid delegation. Here, the incorporation is the reference to the arbitration rules of the American Arbitration Association. That's quite common in agreements between sophisticated commercial parties like the parties here. And among the relevant rules is Rule 7A, which authorizes the arbitrator to make that determination. And this court has never required magic words on the face of the agreement. Instead, all that the court has said is that you have to have clear and unmistakable evidence. And under ordinary objective principles of contract formation, the incorporation of a document suffices in order to render that document part of the contract.
Thank you.
Justice Breyer?
Need experience of arbitration in the labor area for this question. I assume that George Berman's brief makes a big argument about the AAA, but I won't accept that for purposes of this question. Assume there is clear and unmistakable evidence of delegating the arbitration matter to the arbitrator in general, okay? You got to somewhere. Now, I also think the first options rest heavily and basically repeat AT&T. So I've read AT&T about 5 times. What it seems to say is if you have a question, parties, or one of them, whether this dispute falls under the terms of the contract that have arbitration, falls paragraphs 1 through 7, or is rather a Section 10 dispute where there is no arbitration, clearly. You don't know if it's a Section 8 or a Section 10. Well, what happens? What AT&T says, but that is a question of arbitrability. It is a question of whether this dispute is arbitrable. So it's for the judge. But where there is an arbitration clause in the contract, as there wasn't in first option as far as the owners knew, but where there is an arbitration clause, then there is a presumption of arbitrability. All right? So that seems to me, Judge, you decide whether this particular dispute is sent to an arbitrator or for the court, i.e., is it arbitrable? You decide, Judge, but if there's an arbitration clause in the contract, you decide with the presumption of arbitrability that it will normally be arbitrable. That's what it seems to say. And so the judge was right to decide it below. But he didn't decide it right because he should have given it a presumption of arbitrability. Now, that's how I read those two cases. But also in the back of my mind is what in heaven's name happens to labor arbitration. In the ordinary labor arbitration case, and that's where all this law comes from, where one party, the labor union, says, this is a Section 8 agreement, arbitration. No, says the employer. It is a Section 10 kind of situation, grievance. And therefore it falls within the exception, don't arbitrate. How do they decide that? The scope. See, that's like the scope of the arbitration clause in the agreement. Did you follow that?
I did, Justice Breyer, and let me attempt to answer it very briefly, and I'll make 2 points. The first is that the first options rule, with which I know you are well familiar, does come from the labor context, but I think it operates in the same way. And I think it's easiest to understand this conceptually if you think about the delegation as a kind of miniature contract formation. In other words, was there a meeting of the minds that the arbitrator should decide questions concerning the scope of the arbitration agreement? And that's precisely why we think an incorporation is sufficient, because under ordinary principles of contract formation, that is enough. And then once you have that clear evidence, the presumption flips to the normal presumption because you treat the delegation like an arbitration agreement, and you apply the presumption of arbitrability.
Absolutely.
Thank you, counsel.
Who does that? The judge or the arbitrator?
If there's a delegation, it's for the arbitrator to make the
Where have
determination.
where have you got the precedence of that? Because when I read the 5 paragraphs in AT&T, it seemed to say, yes, that's the rule you apply, but the judge should apply it because it's a question of arbitrability.
Very briefly, counsel.
If you don't have a delegation, then of course it's a question for the court to decide.
Justice Alito?
What do you understand to be the basis for the presumption of arbitrability? It was recognized, I think, the first time in Moses Cohen, and the court said that it was based on the federal policy favoring arbitration, and it cited Section 2 of the Federal Arbitration Act. But the Federal Arbitration, Section 2, we have also said, requires equal treatment of arbitration contracts and other contracts. So what is the basis for saying that there is this federal policy that produces the presumption that you rely on?
It's a good question, Justice Alito, and I'm not sure that the court has ever spoken to it, so let me offer a potential explanation. As you rightly point out, this court has repeatedly said that Section 2 of the Arbitration Act, along with other sections, establishes the principle that arbitration agreements should be enforced according to their terms. But I think this court has also recognized the presumption in favor of arbitration as flowing from the policy underlying the Arbitration Act as a whole. And that presumption in turn, to pick up where Justice Breyer left off, seems to come from the labor context, where, of course, under federal law, you have the Labor Arbitration Act, and you have in that act, in the NLRA, a recognition that federal courts can recognize federal common law. So I think if I were pressed, I would say it's probably ultimately a matter of federal common law, but it also appears to flow from the terms and the structure of the statutes themselves.
Okay, and very, very quickly, I have basically the same question as the Chief Justice. This case comes to us in a rather artificial posture, so we're required to assume that the contract incorporates, that the contract provides for the arbitration of the who decides question across the board. And of course, if that's true, then the answer to the question that we're supposed to decide is foreordained. But if we put that, but isn't that artificial? When you have a carve-out and the parties have taken pains to say, this subject, we don't want the arbitrator to have anything to do with this subject. We want the judge to decide this because this is something that needs to be decided in accordance with the law. And we know that arbitrators have a lot more leeway in interpreting contracts. Isn't that relevant to the question of the scope of the delegation of the power to decide who decides?
That is the very question before the court. And very briefly, Justice Alito, our interpretation makes complete sense because under our interpretation, the carve-out operates as only a carve-out from the scope of the arbitration agreement. It gives the court the power to enter preliminary injunctive relief pending an arbitration. But the question of who decides is a discrete one, and it wouldn't make any sense for the parties to carve out from that absent a clear indication to that effect.
All right, thank you.
Justice Sotomayor?
Counsel, you make much of the fact that we didn't grant cert on the cross petition. But in your opposition to the cross petition, and even in your reply on the merits, you say we can reach the issue. In fact, you admitted in your cross petition that we could affirm on alternative grounds and that it was incorporated, and you encouraged us not to grant it. So I don't understand how you can tell us that we have to assume there was a clear delegation of both the exception and all other disputes. So sort of educate me as to, having said we could, why you're saying we can't now?
Justice Sotomayor, you, of course, could decide the incorporation question, and I don't think we've ever disputed that. Our submission today, as in our earlier briefs, is simply that the court shouldn't. And very briefly, to go back to what we said at the cert stage, we said that a cross petition was unnecessary, but then we proceeded to devote, I believe, 6 pages of our opposition to the cross petition in explaining why the court shouldn't add the incorporation question to our cert petition, namely because there was not a circuit conflict.
All right. May I just ask a question? First option makes it very clear that we have to have a clear delegation. But I think what the court below said was what is unclear is whether the form of the delegation here was intended to be included in that arbitrability section. There's a very limited holding saying where a party says, I will arbitrate all disputes except a particular one. The issue is whether a particular one was delegated to the arbitrator in the following arbitration agreement. Seems pretty logical, not an argument that the court below adopted doesn't seem to be irrational or even nonsensical. Seems fairly natural to me.
Justice
So
Sotomayor,
if I believe there's ambiguity in what was intended to be delegated or not, how do I rule in your favor?
because of the presumption of arbitrability, and that is where the Court of Appeals went wrong. The Court of Appeals did think that the scope of the delegation was unclear, but once you have a delegation, this Court's decisions make clear that you treat that like an arbitration agreement, and at that point you have to apply the presumption of arbitrability.
Thank you, counsel.
Justice Kagan?
Mr. Shanmugam, you acknowledged, I think, to the Chief Justice that however likely or unlikely you think it might be, however logically flawed or completely natural you think it might be, that parties can divide up arbitrability questions and give some to judges and some to arbitrators. Is that right?
Yes. So if I could say one thing.
No. So let's assume the following. Let's assume the provision that says, except for actions seeking injunctive relief, we, the parties, agree that we'll, number one, arbitrate any dispute arising under this agreement, and number two, that the arbitrator will decide all questions of arbitrability. Wouldn't it be clear on its face of that the parties had given questions of arbitrability to the courts in actions seeking injunctive relief?
I think that that's a closer question because of the way that you've modified the provision.
I don't think I've modified the provision at all. I mean, I've basically turned the reference to the AAA rules into a delegation, which is what you want me to do. And then I've suggested that the reading of this provision, that the accept clause applies both to the agreement to arbitrate disputes and to the delegation.
I think you've made a subtle but important change because in this provision, the relevant incorporation is introduced by, in accordance with, and in our view, the carve-out really operates only on what is subject to arbitration. Now, even if you disagree with me on that, I think I would be left with my point that it is unlikely, and indeed, in my view, absurd to think that the parties would define a carve-out that is coterminous both with regard to what is subject to arbitration and with regard to what is subject to the delegation.
Well, Mr. Shanmugam, I think it's not absurd for exactly the reason that the Chief Justice said, that once you decide that certain questions should be in the court here, suits involving, that certain suits should be in the court, here suits seeking injunctive relief, you're not going to want to go to the arbitrator to decide whether suits plausibly seeking injunctive relief are in fact that. You would just want to keep this in the courts generally. So there's nothing unnatural or logically flawed to say, look, if you have something which at least arguably seeks injunctive relief, the court should deal with the question of whether it does and then should go on to decide the issue.
Justice Kagan, you could say the same thing regardless of whether an arbitration agreement contains a carve-out. And so suppose you had this very provision without the carve-out. Any dispute arising under this agreement shall be resolved by arbitration in accordance with the AAA rules. If you have a dispute about whether something is in fact arising under the agreement, in our view, that should go to the arbitrator by virtue of the incorporation. The mere fact that
Justice Gorsuch?
Mr. Shanmugam, I'd like to return to the line of questioning Justice Alito was pursuing, and that is the presumption in favor of arbitration and exception for clear and unmistakable delegations of arbitrability. These presumptions that we've recognized in our case law, you indicated had both a statutory and a common law basis. I want to understand your statutory argument better for the moment. Assume I'm going to put the common law ones aside. You pointed us to Section 2, but Section 2 seems to suggest we follow normal contract rules in trying to discern the parties' intentions. What am I missing?
I don't think you're missing anything, Justice Gorsuch, because I really do think that the court has never spoken to this. But I think, quite frankly, that the origins of what we refer to as the first options presumption, but it really originates in the court's labor cases, are frankly somewhat more nebulous. If you trace that back, it really traces back to a footnote in one of the steelworkers cases that in turn relies on a law review article written by Dean Cox. Now, there's no better person to have write a law review article than Dean Cox, but ultimately, I think that that presumption just rests on an empirical presumption that parties often don't focus on arbitrability. I think, by contrast, the presumption in favor of arbitration is a venerable one, often reaffirmed and applied by this court, and it's one that applies across the board. And again, it simply reflects the strong federal policy in favor of arbitration.
I'm still waiting for a statutory argument, though. I get that there are venerable law review articles and lots of statements in our cases, but is there indeed any statutory basis for any of these?
Well, I think I can't do really much better than Section 2, and as I acknowledged earlier, I think there is some tension between the principle that it applies according to its terms and the presumption in favor of arbitration. My point, Justice Gorsuch, is simply that All that the court needs to do in this case is to apply the presumption in favor of arbitration to the delegation to rule in our favor. And what the court shouldn't do is what respondents suggest, which is to extend the first options presumption beyond the context of whether or not there is a delegation to the scope of the delegation. The latter is a question of contract interpretation, and it should be governed by whatever the general rules are that govern the interpretation of arbitration agreements.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Shanmugam. I want to make sure I have the roadmap clear here with you. The premise of the case, as you're presenting it to us, is that this contract language expressly delegates the question of arbitrability to the arbitrator, correct?
Yes, that's right, or by incorporation, to be sure.
Yeah, by incorporation, and you say if we want to figure out whether the AAA rules actually are an express delegation, we should grant cert on that question at some point and decide that. But for here, we can assume express delegation, correct?
Correct.
Okay. And then your point is that the Fifth Circuit, I think this is your argument, confused the question of arbitrability, namely what subjects are decided by an arbitrator and what subjects are decided by a court, confused that question with the question of who decides arbitrability. Is that right?
Yes, also correct.
Okay. And then in the real world, I want to pick up on some of Justice Kagan's questions, kind of real world, how people draft these contracts, what they expect. My understanding was that the question of who decides arbitrability, who decides question, is almost never divided between a court and an arbitrator, because that would be almost nonsensical in the real world. You need one person to decide, and it's either going to be the court or the arbitrator, not both the court and the arbitrator. Is that correct?
That's correct, and I'm aware of no examples of such a division.
Right. Or am I? Okay. And then in considering the effect of a carve-out, I guess that would apply, as I understand it, to every arbitration contract, or virtually every arbitration contract, because every arbitration contract specifies either limits or has carve-outs. And so if that alone means the court decides what is arbitrable, then the court will always decide arbitrability and really eradicate the idea that arbitrators can ever decide arbitrability. Is that accurate, or am I missing something?
Yes, that's correct, and that gets to the point that I made in response to Justice Kagan. If you take a look at page 119 of the Joint Appendix, you'll see the AAA's model arbitration clause, and that provision is very similar to the provision at issue here, except that it lacks the except for language. And as I indicated, you would have exactly the same question when you have a dispute about whether a claim is in fact arising under the contract or out of the contract.
Right. Can I ask one last question, Mr. Shanmugam? Sure. I think this picks up on maybe the premise of the Chief Justice's question. What if the arbitrator does something crazy and says actually that a clause for injunctive relief doesn't mean what it says, or a carve-out for injunctive relief doesn't mean what it says, and I'm going to have an injunctive claim decided by the arbitrator? What happens then?
That would be subject to very limited judicial review under the Federal Arbitration Act and under Section 10. But, of course, that's just by virtue of the operation of the Arbitration Act that review is so limited.
But there is judicial review, at least of some sorts, if that happened.
I think most courts of appeals have said that there would be under those circumstances.
Justice Barrett?
Mr. Shanmugam, I really just have one question, and it goes to the premise of your argument, which is that there was a clear and unmistakable delegation of all questions of arbitrability in the first place. Because, basically, as I understand it, your argument is, given that clear and unmistakable delegation, the presumption was flipped, and so the Fifth Circuit was wrong to read this carve-out as a carve-out from arbitrability as well as to the what and the subject matter of the dispute. Let's say that we're not going to address the question on which we denied cert, which is, whether reference to the AAA rules suffices to be that clear and unmistakable delegation of arbitrability. Here, as you point out, this carve-out, you say that it would be nonsensical, even though parties can do it because they can contract and agree to what they want to, that it would be nonsensical to carve up arbitrability questions. If that's true, why isn't that reason to interpret this clause as not being a clear and unmistakable delegation of all questions of arbitrability? I mean, is just the invocation of the AAA rules enough, given the inclusion of what you say would be a pretty odd language?
Justice Barrett, I think the problem with that argument is that the agreement incorporates by its terms all of the AAA rules, not just some of them, as respondents suggest. And so the carve-out would, at most, limit the substantive scope of any delegation. And I want to make one further point about the relationship between these two questions, because I think a number of the questions this morning have touched on this. Even respondent concedes that the incorporation question is discrete from the carve-out question. Indeed, in an earlier filing in response to our stay motion, respondent said that the court need not reach the incorporation question in order to resolve the carve-out question. So I do think that it is appropriate for the court to assume, as 12 circuits without a conflict have held.
But let me interrupt you just for 1 second, Mr. Shanmugam. Is it enough just to incorporate and invoke the AAA rules? Does that in and of itself constitute a clear and unmistakable delegation, no matter what else the provision may say?
I think that it is enough for there to be a delegation by virtue of Rule 7A. As a matter of contract formation, there is an agreement to arbitrate arbitrability. At that point, Justice Barrett, everything else that we're talking about is a question of interpretation. It's a question of the scope of the delegation. And this court in Renner Center and its earlier decision in this case has said that at that point, the rules applicable to arbitration agreements and the interpretation of arbitration agreements apply. The Court of Appeals' legal error here was in failing to apply the presumption of arbitrability.
Thank you.
A minute to wrap up. Mr. Shanmugam.
Thank you, Mr. Chief Justice. This is an unusual case because respondent makes no real effort to defend the reasoning of the Court of Appeals in the decision below. Instead, respondent is really asking the court to decide this case based on a different question, the incorporation question. And that would be a bold strategy in any case, but I would submit it's a particularly bold strategy here because respondent asked the court to decide that question at the third stage, and the court seemingly consciously made the decision not to add it. Now, that question, in our view, doesn't warrant the court's review, and it doesn't warrant the court addressing it here in light of the overwhelming consensus of the lower courts on that question. But if the court were to reach that question anyway and to reject the consensus view, it would have dramatic consequences for innumerable commercial contracts that are worded much like the contract here. All that the court need do in this case is to hold that the Court of Appeals' actual reasoning is inconsistent with this court's decisions applying familiar Federal Arbitration Act principles, and for that reason, the Court of Appeals' judgment should be vacated.
Thank you, counsel. Mr. Geiser.
Thank you, Mr. Chief Justice, and may it please the court. The arbitration clause here does not delegate any gateway questions to the arbitrator, and even if it did, the party's contract clearly exempts this dispute from the scope of any delegation. Petitioner's contrary contention is incompatible with the FAA, this court's authority, the agreement's plain language, and simple common sense. We submit that the court can affirm for two independent reasons. First, the mere incorporation of the AAA rules is not clear and unmistakable evidence that the parties agreed to arbitrate arbitrability. This court applies an interpretive rule based on reasonable assumptions about the parties' likely intent and presumed expectations. Yet the arbitration clause here is silent on delegation. It does not utter one syllable about it. Anyone actually aware of this arcane issue would address the subject expressly on the face of the agreement, and that is especially so against the backdrop of this court's heightened standard and how easy it is to address the question directly. It is simply not plausible that anyone would recognize this issue and choose to resolve it by relying on an oblique reference to the AAA rule, rather than a simple, explicit sentence delegating the gateway issue. Second, even if there is a delegation clause, it does not reach this dispute. Petitioner says the delegation is hidden in the AAA rules, but those rules do not even apply unless the action falls within the category of disputes subject to arbitration. If an action falls within the carve-out, then it is not subject to arbitration, and it is not subject to arbitration under the AAA rules. It makes no difference what those rules say because the condition for activating them is met. Once the contract is read to mean what it so plainly says, all the confusion disappears. It provides for arbitration generally, it exempts certain types of actions from arbitration, and it requires that any arbitration be conducted under the AAA rules. The only reason petitioner finds simple language bizarre, confusing, or circular is because petitioner is trying to smuggle in a delegation clause where it so plainly does not exist.
Counsel, I think the most important question for you, it's a challenge that your on the other side has laid down clearly, and it was what Justice Kavanaugh was talking about. How do you distinguish a situation we call the run-of-the-mill situation where there is no express carve-out? Just say that the agreement applies to all labor disputes in the factory, and there's a storage facility right next door. They keep things that are used in the factory, but they also have other stuff, and the union says we want to arbitrate a dispute about that building, and the factory owner comes in and says, no, that's not within the arbitration agreement, not part of the factory. Now, why isn't that analyzed the same way you analyze your contract and say, well, that's a question of arbitrability, and that should be decided by a court? What makes that situation different?
Well, I think that what would make it different is if there is an express delegation provision. And normally when parties include an express delegation provision, it's conditional and it's categorical. It's not like what you have here. And if parties are simply referencing the AAA rules, they're presumably doing that.
I wish you'd just leave the AAA rules out of it. I think that's what we tried to do when we denied cert on that question. It's just, I mean, the argument on the other side is that the issue that you're trying to elevate outside the normal situation comes up all the time because arbitrators are always deciding whether something is within the scope of arbitration. That issue has never been treated as a question of side. But why is your case different?
Well, I think that is a question of arbitrability, and the default is the court decides that issue. The only time an arbitrator decides whether a dispute falls within the scope of the agreement is if there is, in fact, a delegation provision. If there is one, and then the question becomes, did the parties expressly carve out certain disputes from the delegation or from the scope of arbitration? We absolutely concede that if the exception is limited solely to the scope of arbitration and there is a separate unconditional delegation provision, then the arbitrator gets to make that determination. The problem here is that my friend's reading is profoundly atextual. If, in fact, the delegation is in the AAA rules, and the sentence says on its face that some disputes, but not others, those seeking injunctive relief, are subject to arbitration under the AAA rules. If this is one of the other disputes, then it's not subject to arbitration, and it's not subject to the AAA rules. The court gets to make that predicate determination.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, let's assume an express delegation here. Would you be able to make the same argument if there were an express delegation?
It depends on what that express delegation is.
Let's just take the AAA. Of course, we're not arguing about that, but basically the same thing, except that you use the term expressly delegates the authority to the arbitrator pursuant to the rules set out in AAA.
Sure, Your Honor, and I don't mean to quibble, but I do think the phrasing matters. If it says that any dispute shall be resolved by binding arbitration and the arbitrator decides arbitrability, then in fact the arbitrator gets to decide it. But if you have the exceptions that are listed here, so it says any dispute except for actions seeking injunctive relief are decided by arbitration under the AAA rules, which means the arbitrator decides arbitrability. The clause for activating the delegation does not apply because the carve-out would apply to the scope of the delegation. It's only when the carve-out is limited to the scope of arbitration. And that really isn't so unusual because most contracts with an express delegation clause, let's say you had this exact contract at issue in this case, but then there was the second sentence that said the arbitrator shall decide arbitrability. In that case, we would lose because there'd be an express, unconditional delegation of the issue of arbitrability to the arbitrator. The problem here is that the exceptions to the disputes subject to arbitration and subject to the supposed delegation are limited, and the carve-out applies to the category of disputes that otherwise would be subject to a delegation.
So if I understand you then, your argument is that, well, who determines that? Would that then be the court? So you would actually say that with respect to the carve-out, the court makes the determination. Well, it seems to me you're taking it away from the arbitrator then.
Well, Your Honor, unless there's clear and unmistakable evidence the parties wanted the arbitrator to decide arbitrability, then the default is with the court. And the court has to first identify a delegation agreement and identify any limit to that delegation agreement. And I don't think there's anything at all unusual about that. In fact, it reflects the traditional presumption about the likely expectations and intent of the parties, and it reflects the plain text of the Federal Arbitration Act in Sections 3 and 4. Gateway matters are typically resolved by the courts unless the parties expressly say otherwise.
Well, it seems as it's a limitation on the authority of the arbitrator who had, in our opinion, which seems to be that normally the arbitrator would determine arbitrability. And here you're taking it away. So I see what the rub is. I don't know how you can have it both ways. You can say he has the authority, and in these limited circumstances, he doesn't.
Well, Your Honor, I don't think so unless the court wishes to adopt a binary rule that says all delegations are all or nothing. But the court has never said that. Parties are perfectly free under the Federal Arbitration Act to delegate some issues to arbitration and to delegate some arbitrability issues to arbitration. And when the parties phrase the contract the way this is phrased, where they place a limit at the outset on the scope of disputes that are subject to the AAA rules. This contract does not say that all disputes are subject to the AAA rules, even though some are not subject to arbitration.
Justice Breyer?
All right. I've had a hard time because of the words arbitration, arbitrability. It's sort of like it's hard to keep all this in my mind. Okay? So please follow precisely. Assume you're wrong about the AAA. So we assume it is a clear delegation, okay? Assume that.
Okay.
Now, let's assume the Chief Justice's example. Now, if in fact there were a clause in the arbitration clause which said we delegate gateway matters to the arbitrator, it would be the arbitrator who decided whether his second warehouse fell within or outside the clause, right?
That's correct, because it would be an unconditional delegation.
Okay. And in doing that, the arbitrator should apply the fourth rule in AT&T technology, namely a strong assumption in favor of arbitration. Right? I think that's right. All right. Now, what he's saying is, your friend on the other side, look, take a list of 100 disputes between employer and worker. All kinds. They'll go to the arbitrator. Now, one thing on that list of 100 is who should decide the gateway matter of arbitrability. And we have in this contract, it is a contract that contains an arbitration clause, and that arbitration clause deals with gateway matters, and it sends them to the arbitrator. So precisely the same way that we would tell an arbitrator to you decide matters before you decide the warehouse not or not use a presumption of arbitrability, if the whole thing were clear, we should do the same thing here, apply the presumption of arbitrability on the gateway matters, because there is a general delegation of question of arbitrability to the arbitrator, a general delegation of the gateway matter to the arbitrator, and Section 4 says, the fourth principle of AT&T says, where that's so, you use an assumption, a presumption in favor, in this case, of arbitrability of the gateway matter. Now, I think that's what he's saying, but I'm not 100% positive. So if you understood the question, which I hope I did, what's the answer?
I think I did understand it, and I have two answers. The first is that this is not a general delegation to the arbitrator because it's not unconditional. It doesn't say that the AAA rules apply to all disputes. If this is a dispute falling within the carve-out, then it is not subject to the AAA rules. You don't even get there. It's as if my friend likes to say, reproduce the language into the contract itself. But that's not a complete answer. You would reproduce it with the introductory phrase that says, the following paragraph shall not apply in actions seeking injunctive relief. So you don't even look to what that paragraph might say. You don't even get to the AAA rules or any supposed delegation. My second point is I think my friend's attempt to flip the first option standard on its head doesn't work. It's not consistent with this court's decision in Rent-A-Center. Rent-A-Center made clear that typically the court decides the gateway matter. Now, it did say that a delegation agreement is treated the same as any other agreement, but it dropped a footnote that said except when you're deciding if that agreement exists and what it is.
Thank you, counsel. Justice Alito?
Mr. Geiser, I want to ask you for help with a problem that is not at all your fault. It's our fault because we didn't, anyway, it's our responsibility. I won't say fault because we didn't grant the cross petition. But because we didn't grant the cross petition, I want you to assume that we are not going to decide the question that you wanted us to decide in the cross petition. And if we make that assumption, I really don't know how to answer the question that we granted review on, because it does seem to turn on the degree of the delegation to the arbitrator of the power to decide whether the arbitrator can decide. If I'm required to assume that all of that was delegated to the arbitrator, well, then the answer is clear. If I'm required to assume only that part of it was delegated to the arbitrator, then maybe under first options the answer is also clear. So, as I said, if you just want to say, look, this is your problem, not mine, that's fine. But if you can help me with how I could deal with this within the constraints that I've outlined, that would be of assistance.
Sure, Your Honor. And the first is I think it'll be very difficult to intelligently decide this question in anything but the most abstract and artificial way without deciding whether, in fact, this is a delegation provision. Because you're effectively taking a single sentence, you're assuming a counterfactual for what half of it means. My friend is now saying you should construe any ambiguity in this sentence in a way that's profoundly atextual in order to accommodate this fictional delegation. And if the court later decides the delegation question and determines, in fact, as I think we've shown, that this is not a clear and unmistakable delegation, then we'd have to overrule this case if you go against us. So I do think it's very difficult. You could dismiss the case as improvidently granted. You could request additional briefing, though I do think the question is fully briefed. But with all that aside, I still think that we can prevail in this case by simply following the absolute, plain, unambiguous language of what this contract says. I think that my friend's contention is that the case should come on the presumption that incorporating the AAA rules is a delegation clause. It's like a term of art. Now, I think that's wrong for lots of reasons. But if it is a term of art, the term of art does not apply here to any dispute falling within the carve-out. And so once the court construes this agreement to mean just what it says on its face, some disputes are subject to the AAA rules, but other disputes, those falling in the parenthetical, are not. And if they're not subject to the AAA rules, they're not subject to any delegation. And that's just a plain text reading of this agreement, with or without any presumptions. And I think it's the most straightforward way to affirm in this case.
Right, thank you.
Justice Sotomayor?
Counsel, I've been confused because Perhaps it's because, as you should give us a lot of alternative ways for you to win. But I would like to break them down to understand them better. It seemed to me as I read your brief that you were taking the position that incorporating a set of arbitration rules can never amount to a clear and unmistakable delegation. Is that your position?
Our position is that the mere use of this text is insufficient. Now, parties could establish through extrinsic evidence, for example, that you have two arbitration scholars, this is their fifth agreement, they always use this language, they always...
Are you saying that this particular AA language is insufficient?
We're saying that...
No, stop. Let me finish. That this particular set of AAA language is insufficient, or that you can never incorporate an abundantly clear language like the JAMS rules. I think they say arbitrability disputes shall be submitted to and ruled on by the arbitrator. That seems pretty as direct as you could get. If that was part of, if that was the AA rule, for example, are you saying that that itself would not be clear enough?
We are saying that this linguistic formulation is not sufficiently clear because the reason parties would predominantly include this language is for an independent and obvious reason, and it's to set the ground rules for the arbitration.
I still don't think, counsel, please just answer my question. I gave you a clear statement. If that was the rule, could you never incorporate it?
Not using this language, Your Honor. This language in itself.
Not using the exception language. That's what you're saying.
Without just merely referencing the rule. If you replaced arbitration rules of the AAA here with arbitration rules of JAMS, it would still be insufficiently clear and unmistakable.
Okay, because of the exception. Then I did understand you right. I understand the argument. I'm not sure it gets you where you want to be for all the reasons that my colleagues have said, that where someone clearly has set forth that scope of arbitration, which is the AA rule, is up to the arbitrator, then I don't see why we shouldn't honor that explicit request.
Well, Your Honor, first, here all we know from the parties is that they were referencing the rules for the independent purpose of knowing where to show up for the arbitration and who to pay. There's no indication that the parties hid an elephant in a mouse hole and intended the AAA rules themselves to supply this separate contract, which is what it is, to delegate arbitrability. But again...
It does seem to me that I don't see any way to avoid that your position basically says, as long as that every arbitrability issue has to be decided by the court, because every single arbitration agreement has limitations. Almost all agreements say any disputes related to this contract are subject to arbitration. And almost inevitably, a party will come in and say, this dispute is not related to a contract. And what would you have a court do? Decide that issue and then send it to arbitration? Even when a contract says all disputes involving arbitrability go to the arbitrator?
Briefly, counsel?
Sure. If there is an express delegation provision that's unconditional, so again, the same sentence here, there's a separate sentence that says the arbitrator shall decide arbitrability, then the arbitrator would make those determinations. But where the delegation, as here, is limited, the exceptions apply to the delegation, then the court necessarily has to make that determination.
Justice Kagan?
Mr. Geiser, I'd like to ask you about the petitioner's view of the presumptions here. As I understand it, it goes like this. First, we have a presumption that's in favor of arbitration. Then we have an exception to that presumption, which is the first options rule. When the matter deals with arbitrability, we actually presume that the court is supposed to decide those gateway questions. For whatever reason we have those presumptions, the court has said many times that we have those presumptions. Then, as I understand what the petitioner is saying, he's saying, now let's add a third presumption. The third presumption is if we see evidence of questions. So if there's any delegation of arbitrability, there's complete delegation of arbitrability. That's the presumption. And he says that presumption should operate because it wouldn't make sense to do partial delegations of arbitrability. So I would like to hear what your response is to that argument.
Sure.
Fast. I actually just
the agreement in that fashion. But again, the only reason that seems unusual here is because we're dealing with smuggling in a delegation where it doesn't actually belong. The party
But
didn't
assuming as we assumed, that the AAA reference is a delegation.
Yes, Your Honor. And again, assuming that it's still the case and the parties are perfectly free to do this, they can decide we will not bifurcate certain issues between the court and the arbitrator. And injunctive relief is actually a primary candidate for not wanting to bifurcate because it doesn't do parties much good in terms of the goals of arbitration, of efficiency and expediency. You have to go to the arbitrator, get an order for injunctive relief, go back to the court, and seek to enforce that order before the court. And make more.
Justice Gorsuch?
Thank you, Chief. I'll pass.
Justice Kavanaugh?
Thank you, Chief Justice. And Mr. Geiser, good afternoon. First, picking up on Justice Sotomayor's questions on the incorporation of the AAA rules. That's not the issue before us, but just to pause on that for a second, you referred to it as an elephant in a mouse hole. It's really an elephant in the elephant hole. When you look at the AAA rules, Rule 7A says the arbitrator shall have the power to rule on his or her own jurisdiction, including the arbitrability of any claim or counterclaim. That's very broad language, which is probably why every court of appeals to address it has said that the AAA rules are an express delegation. But again, we don't have to decide that here. That's just the premise. But I wanted to just pause on the elephant in a mouse hole point. Here's the problem I think I have with your argument, and you've made it very cleverly and persuasively. But the problem is that you are suggesting that the way parties divide up arbitration, namely some subjects will be subject to arbitration and decided by an arbitrator, and some subjects won't, also applies to the question of who decides arbitrability. So courts will decide whether certain things are arbitrable or not, and arbitrators will decide whether other things are arbitrable. I think that's what you're saying. But that's just not how it works in the real world, nor could it realistically work that way in the real world. I don't think any contract says arbitrability shall be of certain subjects shall be decided by the arbitrator and others of other subjects by the court. You help me on that? Am I wrong?
Well, I think so, Your Honor. I'd like to address the first question first. I don't think this is in fact an elephant in a mouse hole. And the best proof of that is parties use the same linguistic formulation when they have express delegation clauses.
Can you just go to the second question since time's limited?
Sure. In the real world, parties sometimes do limit a delegation. They might say that the court decides whether class arbitration is appropriate, and parties are perfectly free to do that. And here, if the parties decide, and I think on the face of this agreement, aside from just saying it's absurd, so we're going to toss aside the plain language of what the parties actually wrote, in the context of the Federal Arbitration Act, which is trying to enforce contracts according to their terms.
Well, I think it's, just to interrupt, I think what we're trying to figure out, does the carve-out apply to what subjects go to arbitration, or does the carve-out also apply to who decides arbitrability? And I think to the extent there's any ambiguity on that, the alleged absurdity seems quite relevant to deciding that question.
That's fair, Your Honor, but I don't see any way to read the actual text of this agreement to say that the carve-out wouldn't include a carve-out to the AAA rules. Again, it would be different if the party said all disputes are subject to the AAA rules, even though only some disputes are subject to arbitration. That's simply not what they wrote. I don't see any way to say that parenthetical carve-out applies, to anything other than the disputes that are then subject to arbitration under the AAA rules. If it's not one of those disputes, it's not subject to arbitration under the AAA rules.
Justice Barrett?
So, counsel, I feel a little bit like Justice Sotomayor. This case feels like it's a little bit all over the map because you've offered us several different ways to rule in your favor. And I just want to be sure that I understand your argument. And so you should take as your premise that we're not addressing the question on which we denied cert in your cross petition on whether incorporating the AAA rules by reference constitutes a delegation. Is it your argument that, first of all, there is no clear and unmistakable delegation here at all, so you win, or alternatively, that even if there was a general clear and unmistakable delegation, that the carve-out provision carved out arbitrability as well as subject matter?
Well, Your Honor, I think our first position is there is no clear and unmistakable delegation at all. But the second is, and most of that argument, just to be perfectly candid, is premised on the idea that the mere incorporation of the AAA rules is insufficient. But setting that aside, I do think that once you have a dispute that falls within the carve-out.
Okay. So I have correctly understood your argument.
I believe you have.
Okay. So on the first point, and you said to be candid that most of that argument does turn on the AAA rules, the incorporation of them not constituting a delegation. If we don't address that question, and if we just decide this case assuming that it can be, do you lose on the first point?
I don't think so, Your Honor. I just want to be very careful on how I answer this. We do lose in the sense of if you're presuming that referencing the AAA rules means that there is some form of delegation to the arbitrator, but we don't lose in the sense that there are still limits on the scope of that delegation.
Okay. I didn't mean, so you're referring to your second route to victory, right? I'm just asking on the first point, do you lose on your argument that there was no clear and unmistakable delegation at all if we, declining to get into the question that we denied cert on, assume that incorporating the AAA rules by reference is enough to constitute a clear and unmistakable delegation? Do you lose on your first argument if that's how we approach it?
I think we likely do. I mean, there are multiple layers of that argument, but I think in the interest of time, we likely do.
So it's not your position that it's possible to incorporate the AAA rules by reference, but still, through the context of the language and the provision, not intend simply by reference, by incorporating the AAA rules to clearly and unmistakably delegate. You don't have kind of a halfway position on your first argument.
No, Your Honor, and I'm sorry, I misunderstood then what you were asking me to concede. Part of our reason that we don't think that this language is clear and unmistakable is precisely because it is ambiguous whether the parties included that language because they just wanted to set the procedures for the arbitration or whether they were actually trying to address and focus on the concept of delegation in this, subpart of a single rule out of 58 rules that happens to have anything that remotely resembles delegation. So I do think that you can say, in theory, Rule 7A, again, we disagree with this, but it's a delegation provision, despite not having exclusive language and precluding the court from addressing it. And you can still say that just as parties adopt the same linguistic formulation when they want to delegate or not delegate, or before Rule 7A even existed, the bare use of this boilerplate is not enough to show that the parties had any intention whatsoever to delegate.
You have a minute to wrap up, counsel.
Thank you, Your Honor. I think the ultimate problem, and I realize what the court is struggling with, and we apologize for trying to get the court back into an issue that maybe it doesn't wish to address. But I think it is very difficult to construe this language, especially against a presumption that the reason you should not simply read the contract language on its face is to avoid, a potentially circular result if the parties actually wanted an arbitrator to decide arbitrability. And so it doesn't make sense to say then the court would have to construe the carve-out. Again, that is just asking for a profoundly atextual construction of the plain text of this agreement in order to embrace a counterfactual about whether a delegation actually exists. And I think it would be very difficult to construe this language in a sensible way without getting into the delegation. But again, if the court does wish to try that anyway, we still do think that carve-out is clear and unmistakable in saying that only some disputes are subject to the AAA rules, and if this is not one of those disputes, then it is not subject to the AAA rules, and it's not subject to any delegation, and it's ultimately up to the court in its traditional gatekeeping role to construe that language and say what it means.
Thank you, counsel. Rebuttal, Mr. Shanmugam.
Thank you, Mr. Chief Justice. Respondent's entire argument this afternoon keeps coming back to the premise that there is not a clear and unmistakable delegation by virtue of the incorporation of the AAA rules. But respondent has conceded that the court can decide this case on the premise that the incorporation is sufficient. The court can and therefore should assume that the parties agreed to delegate at least some questions concerning whether a dispute is subject to arbitration to the arbitrator. Now, respondent contends that a court should decide the scope of the delegation agreement, and Justice Breyer, of course, we agree with that. Our submission is simply that when a court is making that determination, the presumption of arbitrability should apply. And if it is ambiguous that a carve-out applies to the delegation, a court should hold that it does not, especially given how unlikely it is that the parties would divide up responsibility in that fashion. The purpose of delegation provisions is to assign clear responsibility where there is a dispute about the scope of an arbitration agreement. Now, that dispute can be a dispute about an express carve-out, so as here, whether the action at issue constitutes an action seeking injunctive relief or not. So as in my hypothetical from earlier, whether a dispute simply arises under the parties' agreement. It would effectively defeat a delegation to accept respondent's view because someone would have to decide when there is a dispute about whether the arbitrator or the court should decide arbitrability. And it's one thing to say that parties may want to divide up responsibility for different types of questions of arbitrability, such as who is subject to the arbitration agreement or whether a class action waiver is valid. But as I pointed out in my earlier colloquy with Justice Kavanaugh, we are not aware of any actual agreement in the real world that divides up responsibility for a particular question of arbitrability, and in particular the paramount question of the scope of the arbitration agreement. Justice Kagan, we are decidedly not asking the court to recognize a third presumption here. Instead, our point is simply that once the first option's presumption has been satisfied, because there is clear and unmistakable evidence of a delegation, it falls out of the equation, and the ordinary presumption in favor of arbitrability applies. And that is because, in the words of this court's decision in Renner Center, quote, an agreement to arbitrate a gateway issue is simply an additional antecedent agreement, and the FAA operates on that additional arbitration agreement just as it does in any other. In closing, all we're asking the court to do today is what the court ordinarily does, to resolve a circuit conflict on the question presented and to correct a legal error on the part of the Court of Appeals. Having held that there was a valid delegation, the Court of Appeals failed to apply the presumption of arbitrability to the delegation agreement. This court's decisions make clear that the presumption applies, and that is all that the court needs say in a brief and narrow opinion applying settled law in order to vacate the Court of Appeals judgment. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.